Yes.
made pleasure.
Mr. Hazarika, you
Yes,
have
yes, confining to that whatever
yes,
has been submitted.
yes.
My lord, the issue was whether uh, rent has been paid. There was an arrear.
Mm,
That is one of the issue. And second, on default of rent,
mm,
whether an occupancy tenant is liable to be evicted.
mm,
My lord, to be honest, on that part I have gone through. Probably occupancy to tenant, my lord, there is no specific provision as such.
mm,
So, as for my substantial questions which we have framed, my lord,
mm,
there are basically two questions which which was to a my lord.
mm.
Whether occupancy that is A, I have taken whether occupancy tenant is mandatorily liable to pay rent, proceeds out of the land, so belonging to the landlord. My lord, this particular issue, which was point number 4, issue number 5 in both the trial court and the appellate court. This my lord, present appellant as defendant, my lord, claimed that since 2012 arrears were pending, and prayer was for twofold, my lord, realization of the arrears as well as ejectment. That ejectment part, my lord, I will leave it to your lordship, because although the act is not specifically saying that in default of rent he will be liable to be ejected, that is not there. But my lord may always draw a ruling. That is one part.
Pardon?
My lord may because since, my lord, if we go by the
No,
tenancy,
if there is no provision in the
Yes, yes.
statute and the rules, then how can this court go out of the same?
that part I am leaving, man. So that part I am, my lord, that part I am conceding that to that, my lord. But area we will be entitled. That my
You
learned
are entitled to area, that's all right. There is no doubt about it. But there is provision in the act. You go for rent suit.
rent suit that this counterclaim was for realization of rent only, as well as ejectment. So ejectment part I understand, my lord, may not be possible. But the arrears, my lord, because from the very beginning, from the plaint itself, my learned friend, my lord, responded, my lord, he has also admitted that there was default in area. So already we have, by way of a counterclaim, my lord, we have sought for that relief. So that may be
So
my
your counterclaim was rejected by both the
counterclaim was
court below.
rejected. Defendant number 1, counterclaim rejected. Counterclaim on two ground, to realize the arrears as well as ejectment. I understand ejectment may not be
So
possible.
let us say what is your
Yeah.
pair in the counterclaim.
Yes, yes.
Page number?
Page number 20, 23, 22, 25. Specific amount were also mentioned, my lord, at that point of time.
Whether any issue was framed on this point?
Yes. Point. At page number 40, page number 44, by in the trial court.
44.
44. Paragraph 23 and 24, 25. All.
Paragraph number 20.
23, my lord. Now coming to issue number 5, which is in respect of claim of the defendant, counterclaimant, that in the year 2012, the plaintiff lost the status of tenant for non-payment of rent.
So this is the finding recorded by the learned first appellate court,
No, my lord, this is by the trial court.
trial court.
And same view is taken by the appellate court also
Where
at
is
page
that finding?
51.
Page number
51.
51.
My lord, may I just submit, my lord, last occasion also I have 51, my lord. কিমান আছিলে? Sorry, my lord, page appellate court. Page 70, 75, sorry, my lord. My point, page 77, my lord, sorry. Page number 77. 77, my lord.
But
My lord, here my
whether this is a substantial question of law.
that I have framed as A, my lord. Whether occupancy tenant is mandatorily liable to pay rent. They have to pay rent, my lord. Probably there may not be exactment, but area that can be realized.
No, both the court below has recorded a finding that
Yes.
the evidence adduced by you
On the
for
last occasion, my
non-payment of
lord,
rent since 2012 is not believable.
Yes.
Believable.
my lord, both the appellate court just endorsed what has been decided by the trial court. My lord, my humble submission on the last occasion also, burden of proof is always on the tenant. In their plaint, they have said at page number 11, in their specific paragraph 6,
Page number?
page number 11 of the plaint, original plaint. Paragraph 6.
Yes.
Where the learned court, my lord, my humble submission, the burden is on the tenant. The plaintiff should have first proved that they are paying the rent regularly. And I will substantiate it by the act also. Here, paragraph 6, that a plaintiff inherited the suit land as occupancy tenant of the defendant number 1 and used to pay the respective rents under their occupation. It is stated that a father of the defendant 1 also died and defendant number 1 became owner of the suit property. And automatically the plaintiff regularly paying the rents, that is 1/5 share of crop or its value to the defendant number 1 from the death of the father. This is an admitted fact. And when counterclaim is to the effect that from 2012 it was not paid, burden would be on the tenants to prove that rents were being regularly paid. And my lord, again page number 33, there is an admission. Page number 31. This is the, my lord, written statement submitted by the plaintiff in respect of the counterclaim. Here, 31, page number 31, my lord, paragraph 18. They admitted that their rent was not paid, my lord. They say, my lord, the answering plaintiff also asked the defendant number 1 to take delivery of the share of crops.
Page number?
Page number 31, paragraph 8. This is, my lord, written statement against the counterclaim by the defendant.
Paragraph number?
Paragraph number 18. That on getting the summon of the instant suit, the defendant 1 served a notice upon the answering plaintiff with a demand to pay the rent, share of the crop for their occupation. The answering plaintiff also asked the defendant number 1 to take delivery of share of crops from the answering plaintiff, but with some ulterior motive, the defendant number 1 did not want the plaintiff and did not went to the plaintiff and failed to take the share till death, which means that devil mind of defendant number 1. My lord, I'm coming to that provision. Tenants are burdened with the fact that they have to prove the rent.
Which provision?
Provision number 37 of the Assam Temporary Settled Areas Act. On the last occasion, my lord, if my lord recalls, my lord, my learned senior friend also admitted that there is a default in rent. Yeah, 37 says, my lord, every tenant who pay his rent shall be entitled to obtain forthwith from his landlord a written receipt signed by the landlord or his authorized agent. The receipt shall contain a description of the land for which the rent has been paid, the total amount of rent due, the amount of rent in cash or the quantity or rent in kind has been paid, and the year for which it has been paid. If a receipt does not contain substantially the above particulars, it shall be presumed until the contrary is shown to be full acquittance of the rent due from the tenant. It will be understood that rent is due if such money receipt, this rent receipt could not be produced. When a landlord or his agent without reasonable cause fails to deliver to the tenant a receipt as required by the foregoing subsection, the landlord shall be liable to pay as compensation to the tenant a sum not exceeding 200 rupees for his defaults. My lord, this process were not taken by them. That there were no plea that the rent receipts, regarding rent receipt, there is nothing on record to show that they were depositing the rent regularly. And 2, my lord, clearly says that it will be taken that a rent is due from the tenant if such money receipt is not there. So admitted position, my lord, from 2012, rent area is there, my lord. But that may not be a ground for ejectment, but area is there. And I am entitled for arrears, realization of the arrears till date. My lord knows, my lord. If the landlord refuse, there is a process, my lord. It can be deposited in the court also. So, my lord, now I'm coming to, my lord, the final decision of the trial court, my lord. Last part, my lord, operative part at 46, my lord. 46, my lord.
Page number 46.
46, my lord. The finding of the trial court.
Yes.
31, my lord, order. In the result, the suit is partly decreed on contest with cause, declaring the plaintiff right of use and occupation over the suit, confirming their possession over the suit land as well as for permanent injunction. The counterclaim of the defendant number is dismissed on contest without cost. Here I am agreed, my lord. At least arrears we are admittedly entitled, my lord, because that learned court below, my lord, only put burden on me that I have to prove that from 2012 I have not received. Did not discuss anything, but my lord, burden lies on the tenant to prove. They have taken a plea, a specific plea at paragraph 6 in the plain that they are paying the rent. They are paying the rent. This may not be a ground of ejectment, but I am entitled to the arrears, realization of the arrears till date, my lord. And finally, my lord, the appellate court final order, my lord, at page 80. Here there were modification, my lord.
Yes.
Here, my lord, from the discussion made above, plaintiff 1, 2, 3, 4, 5, and 10 are entitled for a decree of declaration of the right of use, occupation over the suit land, confirming their possession over the suit land as well as permanent injunction. However, plaintiff respondent do not have the title over the suit land as the same is owned by defendant number 1. This is, my lord, this is held by the appellate court.
Mm.
This is modification, my lord. At page 80. The title is with the defendant number 1. But, my lord, again, it said that counterclaim made by the defendant could not be proved by preponderance of probability. In any manner, my lord, I am still having the title. So I am definitely, my lord, liable to get the rents. I'm entitled to get the rents.
Okay.
This is
Yes.
my submission, my lord.
Regarding non-payment of rent, there is no specific allegation. Yeah. Planet, you are the learned trial court as well as the appellate court, both the courts held that the non-payment of rent that could not be proved by the other side.
But the question is, burden is lies upon whom?
I heard, yes, Section 37. That's on duty on the landlord to give a receipt of the rent. But in this case, admittedly, there is no any mode of payment of rent. And they have not given any rent receipt. That is an admitted question. But as for Section 37, subclause 4, the landlord has a duty. If he fails to give the receipt, then he will be penalized. That is the mandatory duty on the landlord to issue the rent receipt. But in that case, admittedly, they have not issued. So I could not file any rent receipt. But in the counterclaim, I have specifically stated that up to 2015 I have paid. And for the year 2016, I have asked the opposite party to collect the rent for 2016. And secondly, another point is also there. They are saying that from 2012, they have not given the rent. Even assuming that they have failed to pay the rent, they could have filed as rent suit before the appropriate court within limitation. But from 2012 up to 2016, they have not filed any suit. They
So
have
it is
filed-
barred by limitation.
Yes, madam. Because they have filed a suit counterclaim only when I have filed a case against them for the first time. And the issue relating to non-payment of rent has been specifically discussed by the learned both the courts below. Because they could not prove when they went to collect the rent. Even the evidence in support them, he would not say the time of going for collecting rent and whether they went for rent or not. Those were not proved. So they have failed to prove that they went for collecting rent.
No, no. Usually burden is always upon the tenant.
Yes, my lord. I have stated in my petition that I have paid up to 2015.
Hmm. But you have not produced any rent receipt,
When the rent receipt is
not issued by the landlord.
that was the duty of the landlord. To give the receipt. So, that's been specifically stated, when a landlord or his agent without reasonable cause fails to deliver to the tenant the receipt as required by the following subsection, the landlord shall be liable to pay as compensation to the tenant. So in case of failure, he is to pay certain compensation. That is, yes, I am entitled. That is a mandatory provision. When he did not issue any receipt, rent receipts, how would I produce those receipts? May I go to the issue decided by the landlord? It has been specifically stated regarding rent.
Oh, yes, it is stated that could not proved.
Yes. And not a single point was raised before the learned lower appellate regarding rent rates. That is clear, man. Page 55, man.
Yes.
grounds. Ground, court at the largest, as you have got it. Court at the largest. Judge Lakhimpur has delivered the judgment and decree legally and capriciously as they are not in conformity with the existing provisions of law relating to tenancy of land. Court at the learned trial court committed miscarriage of justice by dismissing the counterclaim of the appellant and partly declaring the claim of the respondent, thereby giving a large of appellant's land to the respondents permanently by issuing permanent injunction. The court at the learned trial court has wrongly decided the issue without applying judicious mind. The learned trial court has admitted that in parent number 21 of the judgment that the plaintiff 678 would not produce petitions issued in favor of their fathers, but opines that the appellant has not disputed the claim of the respondent in his written statement. Unfortunately, the learned court below has failed to notice that the appellant has clearly denied the right of testimony in parent number 11 of his written statement, and that the respondent has sought shelter of the Assembly Tenancy Act 71. So in that ground also, he could have raised that point, but he did not raise that point. For the learned trial court has committed grave error by law, dismissing the counterclaim of the appellant as there is every reason to decree the same on the basis of evidence used by the party. For the learned trial court has taken a bias in favor of the respondent and as such, the judgment delivered under such guidance is illegal and not acceptable. For the learned court below has failed to appreciate pleading, evidence and documents submitted by the parties, the judicial and perspective, and thereby committed grave error. For that so not a single point was raised. My humble suggestion.
My lord, 37, my lord. Just, my lord, what my friend. When a landlord or his agent who reasonably cause fails to deliver tenant receipt or required anything on record to show that, my lord, the landlord has refused to issue such that rent receipt. My lord, on not only rent receipt, my lord, anything corroborating evidence, my lord, or of statement, my lord, anyone that they were paying the rent. No such evidence, my lord.
No, their contention is that a landlord has not issued the rent receipt.
Yes.
Then how can they establish it?
My lord, if suppose some rent receipts were not issued, my lord, then, my lord, 38 would come when a landlord refuses to accept any rent when tendered to him by a tenant, or when the tenant is in bona fide doubt as to why he is entitled to receive the rent. The tenant may make an application to the revenue officer. Or if my lord 37(4) is not, my lord, issued, is anything on record to show that, my lord, I have refused to issue rent receipt, my lord. It is the duty of the tenant to prove the rent, my lord, that they are proving it. They are paying it.
Refusal does not come at all. Because they have accepted it. Only in case of refusal, this 38 is applicable.
My lord, here the receipt shall, every tenant who pays his rent shall be entitled to obtain forthwith from his landlord a written receipt. Why they were not taking, my lord? And burden always lies on the tenant to prove that he is paying rent, my lord. Not only money way of rent receipt, my lord, by any other means, by any cogent evidence. My lord, in view of the appellate court, my lord, since it has been decided I am having the title, I am entitled to rent till date, my lord, since 2012, my lord.
2012.
12, my lord.
This is limitation?
Limitation, my lord, it is running, 2012, 2013, 14, they are not paying, my lord. So it is a continuous, because limitation, if we say 3 years also, then I am entitled to a rent of 13, 14, 15. It is a continuous rent, my lord. It is not that I'm asking only rent of 12. Then there may be limitation, my lord. I'm asking 12 to till date. And my lord, they could have, if from, it is at admitted position, my lord, let my learned friend deny that from 2016 onward, what is the position? Whether they paying rent, my lord? Let them say that this question may be answered, my lord. Since 2016, filing of the suit, my counterclaim, can they show anything on record? Whether they were submitting before the revenue officer or before the court? My lord, there, that part may be clarified, my lord. So till that, as my lord title is, all right, my lord, we are not in a position to eject them. There may be some other way out, but not for default of rent. But my lord, my land, my lord, I am entitled to the areas, my lord, and rent in future also. So my humble submission, my lord.
No, Mr. Hazarika,
Yes, my lord.
you see, in second appeal, this court has to confine itself only to the substantial question of law.
Yes, yes.
So what is the substantial question of law framed by this court?
My lord, that was that particular C, if we say, my lord, C, that page number 5, with
No, you come to the order
order.
dated 31/5/2023 by which the second appeal was admitted by
Yes, sir,
framing
order.
only one substantial question of law.
Order to send. My lord, I am not having that order. Okay. Okay. So I have to come to point. But this will be sufficient, my lord, to decide that. Because when the appellate court held that I'm a tenant, I'm a landlord. Admittedly, my lord, it says, my lord, in the very order, my lord, at page 80. This will follow, my lord. However, plaintiff respondent number 1, 2, 3, 4, and 5 and plaintiff number 10 do not have the title over the suit land, as the same is owned by defendant number 1. So, my lord, it will definitely follow up that for the said land, I have the right for rent, and that was what I have. That particular question was framed, my lord.
Okay.
Huh?
Mr. T. Hazarika, learned counsel for the appellant.
My lord,
Doctor.
I have a last submission, my lord. My lord, regarding rent, my lord, I praying before this honorable court, my lord, till date, my lord. And if that part, my lord, needs to be remanded to the, I don't know, my lord, I just keeping it open. Till date, my lord. Otherwise, that will be precluded otherwise, my lord. I will be not able to go for rent since 16 to till date, my lord.
Okay, we'll see. Dr. P.K. Goswami, learned counsel for the respondent. Argument concluded, judgment reserved.
My lord.
Next item.
Deeply authorized.
Item number 10. Item 10.
I think the matter may be passed for the time being.
Who will appear?
GI Babu here. He's on the legs. He'll be
No, if see here, no step has been taken for last 4 years for implementing the legal heirs of respondent number 1 and 2.
Lordship.
You take a step for implement of the legal heirs.
Lordship.
Heard, Mr.
Anally.
Learned counsel appearing on behalf of Mr. J.R. Borbonia, learned counsel for the respondent. None appears for the appellant on call. Office note dated 7/3/2026 indicates that no step has been taken for impediment of the legal heirs of the deceased respondent number 1 and 2. The learned counsel for the respondent submits that he may be granted some time to take step for impediment of legal heirs of the respondent number 1 and 2. Where allowed, recessal is the matter after 4 weeks. In the event of subsequent non-representation of the appellant, appropriate order shall follow.
Item 13.
Hmm.
13.
None appears for the applicant on call is the matter after 1 week. In the event of subsequent non-representation of the applicant, appropriate orders shall follow.
Item 14.
Same order. Same order.
Item 34.
May I please, Your Lordship? As per last order, we are required to file the amended cost title, but unfortunately, we have not filed. Kindly allow 1 day time to file.
Monday,
Monday, Lordship.
heard Mr. Dotto, learned counsel for the applicant, and also heard Mr. Supportive for the respondent.
Full respondent.
Sole respondent. Mr. Dotto submits that due to some inadvertence, amended cost title could not be filed, and he pressed for listing the matter on next Monday.
Yes, Lord.
We are allowed to list the matter on Monday.
Item number 14. I have just been instructed to appear, but while having the time been told that the matter is already over. So my name may be registered.
Okay.
For the
Letter, Mr. Chaudhary, learned counsel. Entered appearance for the respondent.
my lord.
Respondent number
All the response.
for all the respondents. Okay. List after 1 week.
Let it be after 2 weeks, my lord. I'll get
2 weeks.
the papers. Yes, my lord. 2 weeks now. I have to apply. Items for admission. Item number 7.
Madam, we kindly fix at 2 p.m. Lordship. My senior is of the court. He's leave the court. Lordship. He will come back at 2 p.m.
Who is your
Possible.
senior?
Mr. M. Datta. The student side is not there. Lordship. At 2 p.m. Oblige.
May it please your lordship, this petition has been filed by the petitioner for transferring the divorce case being number 55/2025 from Dibrugarh to Gauhati. And that the petitioner is residing at, Maligaon, Gauhati, and the respondent residing at Nahagotia, Dibrugarh. And the case is pending before the additional district judge at Dibrugarh. So from Gauhati, the distance between the Gauhati and Dibrugarh about 440 kilometers. So the matter we prayed before your lordship that the matter may be placed before here at Gauhati or any other court at convenience of this honorable court.
So pair is for transfer of the case from
Dibrugarh,
Dibrugarh to
Dibrugarh to Gauhati, my lord.
Dibrugarh to Guwahati.
Gauhati.
Family court.
Huh?
Family court.
Well, family court Gauhati will be the appropriate place for the petitioner, my lord, petitioner wife, my lord.
The petitioner is residing at Guwahati.
Gauhati, my lord. The petitioner of this petition residing at Gauhati, Maliganj.
Any other point? Any other ground?
Paragraph 8.
Paragraph, kindly, I beg to draw your kind attention, my lord. At paragraph 8, my lord. At page 5, my lord.
Yes,
My lord, may I read, my lord?
yes.
That the petitioner begs to state that the petitioner is a resident of Maligaon, BG Colony, Soti Joymoti Nagar, Guwahati, and Guwahati 77810001, Post Office Maligaon, Railway Headquarters, PS Jalukbari, District Kamrup Metro, Assam. The petitioner is residing in her parental house with her old aged ailing mother and younger brother and sister. She has no income source and now totally dependent upon her mother, younger brother and sister. It is impossible on the part of the petitioner to travel to Dibrugarh in each and every day to attend the court of learned additional district judge Dibrugarh personally. Even she does not have any relative or friend with whom she can go to Dibrugarh or stay in Dibrugarh to defend the case. Moreover, the distance between Guwahati to Dibrugarh is 440 kilometers, and it is quite difficult on the part of the petitioner to travel such distance. Therefore, it will
Okay,
cause.
okay. So the ground distance is the ground.
Yes,
And no income source.
distance and
No income source.
no income source, my lord. She is a poor lady, my lord.
Okay.
But,
Yes. What is your objection?
Husband is, husband is.
In the case with regards to transfer petition village, though the wife convenience is seen village, but there is not a paramount consideration.
Yes.
Village, if I may submit village, there are two things here. First of all, when you seek for a transfer of petition village, I have filed a case before the Nahakotia court.
Mm.
Village, under section 9, for the divorce against the petitioner village. Now, village, I want to just
Naharkotia court.
quote in Nahakotia village. Is the case.
Season.
This is a educated
District Dibrugarh, my lord.
Oh, Malay, this is Dibrugarh, sorry, Malay. District does it Dibrugarh, that's sorry, Malay.
Mm.
This is Dibrugarh. Malay, I want to just produce a judgment
Mm.
on behalf of my objection, Malay.
Mm.
No, Virgin Vita. No.
Yes.
May I read it, Malay? So, Malay, the contention of the petition hearing is this. First of all, Malay, distance is distance respect.
Mm.
However, Malay, when I file a case in Dibrugarh, there are two things that have to be seen, Malay. First of all, I have to prove my own case.
Mm.
I just read 4-5 paragraphs of this instant judgment. But first of all, I come to page number, para number 2.
No. What is the ratio of this case?
Ratio, my lords, in this case, on the very first analysis is given, my lords.
Mm.
On the very first page itself.
Mm.
So basically, my lord, it has been said
Mm.
that seems that
Okay, next second.
Must.
Hearing number 41, number 9.
May I please, Lord? Well, in this case, well, yet to be formulated the substantial question of law. Well, on the last occasion, we have produced some sets of substantial question of law that and those are already brought on record. Cases then appellant before your lordship was plaintiff. Trial court decreed in favor of the appellant before your lordship, my lord, and first appellate forum in reverse decreed in favor of the defendant. Respondent hearing, my lord. Case is that in support of the claim of right title interest, plaintiff relied upon two Javabandi copies and some revenue paying receipts. On the basis of that, learned court decreed in favor of the plaintiff and in reverse, in revert, except some oral testimony from defendants and not a single document has been exhibited or annexed before the trial court. But in reverse, Honorable First Appellate Court decreed in favor of the defendant on the ground that the mode of ownership was not clear. So we have preferred this substantial question of law before this honorable for kind consideration.
There may be only one substantial question of law, that is question number 5.
Well, Lord.
Yes. Sexodinium paragraph. So what happened on 11th of February 2026?
Lordship, 11, last occasion.
Yes.
Well, just we will place the draft formulation, draft subsequent question of no.
Mm.
And today posted for for hearing.
Okay. We'll see and pass the order.
Regarding with due respect, regarding subsequent question number 1,
Mm.
here there is no reason how respondents are entitlement. That reasons is not there. So we are trying to argue that order 41 rule 31D that is not
Reasons are not there.
no.
Order.
Order Lordship 41, Rule 31, 31D, my lord. Where the decree appealed from is reversed
No,
or,
D is, yes, it is not about the reason.
or right, Lordship, the relief which
D
say
is the
applied is
reason for the decision.
entitlement. And that reason is not, my lord. Yeah,
Okay, we'll see.
Lordship. And regarding my lord 3, my lord,
Mm.
whether in absence of any challenge to the mitigation order made before the any competent revenue authority, exhibit 1 and 2 the Jamabandi of the applicant plaintiff attached under section 40 and 41 of the Assam Land and Revenue Regulation so and so carried the presumption to be correct, and it was carried the title and possession of that can be considered, my lord.
You see, the value
as
of
because, Lordship,
mutation is already well settled by Supreme
lord.
Court in several decisions.
My lord,
So it cannot create any right.
Lordship. Well, in rebut, my lord, there is no, my lord, their contention.
Mm.
They have my lord, better claim or counter claim. My lord. There is no counter claim also.
Mm.
So like, it can be formulated as whether exhibit 1 and 2 having been proved as a my lord, correct presumption, Lordship,
Mm.
without any objection by the defendant before the trial court can be ignored by the lower appellate court, Lordship.
Okay, we'll see.
Mile.
Items for-
Highly obliged. Much so.
Item number 15, partner.
None appears for the appellant on call. Parties. None appears for the parties on call. Is the matter after 1 week. In the event of subsequent non-representation of the parties, appropriate orders will follow.
Item 16.
Lordship, I had order dated 9/1/2025.
Mm.
This honorable court framed an additional issue. Whether the
9/1.
impugned judge order dated 9/1/2025.
Mm.
Whether the impugned judgment and decree passed by the learned courts below
Mm.
suffers from perversity not consideration of the point of limitation
Mm.
while deciding the title suit 57/2010
Mm.
and title appeal number 06/2015. While such plea was taken by the appellant in his written statements. Lordship, for the first time I have seen a civil suit where the issue of limitation issue was never framed by the learned trial court, nor the learned appellate court decided the point or a point of consideration, the determinations. When the suit was specifically barred by limitation
Mm.
under section 54 of the Limitation Act.
Article 54 of the Limitation Act. Lordship, let us take that. Limitation Act has two parts. Article 54 has two parts. Part 1, for specific performance of a contract, 3 years. The date fixed for performance, or if no such date is fixed, when the plaintiff had noticed that the performance is refused, we are governed by both. Now, here is the case. Let us take this our exhibits, plaintiff's exhibits, exhibit 1 and 2. That will do. Because this entire matter can be decided on the basis of exhibit 1 and 2.
So first, to decide this point, let us first see the agreement,
Agreement, exhibit 1
exhibit 1. Is it part of this record,
is part of this.
appeal record? Exhibit 1.
1. Let us avoid the first part. Let us come to that. শস্য মাটি বিক্ৰী বাইনা পত্ৰ খতং পত্ৰ মিদং কাৰ্য যোগে.
No, here page number.
Lordship, it may be in the part 1 file. C1 file.
Pardon?
Trial courts records C1 file.
Okay. G1. Exhibit 1.
Exhibit 1. Let us avoid the party's name, etc. শস্য
So when this agreement was entered into
executed
by
on
the parties,
26/4/2007.
6/4/2007.
It is registered one.
No, this is the date of execution or the date of register?
Actually, date of registration is seen.
Same.
Date
Same
of
day.
registration. On the same date, again another sale deed was executed. That is the part of the IA. Should I read that first clause where it is the effective part of it? Exhibit 1 does not say that it is sale agreement. It is not. It is only an agreement. The word sale does not come there. Let us avoid that party's name. শস্য মাটি বিক্ৰী বাইনা নামা খত পত্ৰ মিদং কাৰ্য যোগে যিহেতু মোৰ দ্বিতীয় পক্ষৰ হক সত্তৰ দখলীয় নিম্ন তফচিল বৰ্ণিত 1 কঠা 8 লেচা মাটি 1 নম্বৰ পক্ষৰ ওচৰত চৰ্ত সাপেক্ষে বিক্ৰী কৰিম বুলি প্ৰকাশ কৰাত আৰু উক্ত প্ৰথম পক্ষই উক্ত চুক্তিত আগ্ৰহী হোৱাত উক্ত জমিৰ মূল্য 1,24,000 2,24,000 টাকা বন্দোবস্ত ক্ৰমে আজি বাইনা পত্ৰ বাবদ নগদ 95,000 টকা প্ৰথম পক্ষৰ পৰা দ্বিতীয় পক্ষই সমজাই পাই স্বীকাৰ কৰিছে আৰু দ্বিতীয় পক্ষই উক্ত 1 নম্বৰ পক্ষৰ বাংলাকৃত টকা চলিত বাংলা চনৰ আহিন মাহৰ 30 তাৰিখৰ ভিতৰত দ্বিতীয় পক্ষক ঘূৰাই দিলে এক পক্ষৰ কোনো অজৰ আপত্তি নকৰাকৈ উক্ত বাইনাপত্ৰ ঘূৰাই লবলৈ বাধ্য থাকিল. This is the first clause. If the defendant is able to return that amount by 30th Asin, let us come to the 30th Asin. We have to take that English calendar. 30th Asin corresponds to 15/10/2007.
15?
15/10/2007. Agreement was executed on 26/4/2007.
Mm.
Return clause was, the repayment clause was 15/10/2007. Now, their case is that we could not repay that amount within that period of 30th Asit, which corresponds to 15/10/2007. Therefore, cause of action starts on that day, next day onward. Therefore, that agreement, sale agreement comes into effect. Now, let us come into
It starts from 16/10/2000.
16/10/2007.
2007.
Lordship. Let us come to Exhibit 2 now. Exhibit 2 is the legal notice. This is the document, Exhibit 2.
Mm.
In Exhibit 2, para 3, demand was made on or from first day of Kartik, that is Ahin, 30 Ahin, next day is automatically Kartik will come. Kartik 14/14 of Bengali era.
This legal notice was issued on 26/11.
26/11.
2009.
2009. That is, para 3 says that on or from first day of Kartik, 14/14, Bengali era, my client approached you many times to accept the rest and final amount of rupees 1,29,000 and requested you to execute the final sale deed as per terms and conditions of the agreement, said agreement. But every time you have refused to do so, with some vague or pretext. Here is the case. That was date of refusal comes on 19/10/2007.
Where did that is mentioned?
Because 1910, why it is so first Kartik 14/14 Bengali era correspondence to 19/10/2007. Let's see if I am clear on that point. Because it's so the suit is to be instituted within 3 years, that is by 2010. 19 it was refused. Well, let us forget all the subsequent dates, what they have stated in their plaint or otherwise in this para also. That we have that the refusal comes only on 19/10/2007. Very first day when we refused it to execute the sale deed. This or that pretext, this alibi or that alibi, we have refused. That is their statements. So refusal, the moment specific performance is sought for and it is refused, cause of action starts. That means suit is to be filed from within 3 years of that date. And from record says the suit was filed on 8/11/2010. That is 18 days delay.
Eighteen
18 days delay.
No. Filed on
Filed on 8/11/2010. That means refusal date was on 9/10/2007, which corresponds to first day of Kartik. That is, first Kartik is 19/10/2007. It is their own statements by this demand notice and landed court below heavily relate on this document. Demand notice. So demand was made. We refused to execute the sale deed, final sale deed. That means cause of action starts on that day. And the suit was filed on 8/11/2010. 18 days delay. Therefore, Article 54 comes into play. We have the judgments. Under Section 3 of Limitation Act very clearly says, no suit can be filed with a limitation petition. And they cannot take the plea that subsequently also you have refused it. First they have to refer that it will start only, the cause of action will start only on the first day when we specifically refused. And that is their own statements by the demand notice, which courts below heavily relied on this document. Therefore, I'm protected by Article 54 of the Limitation Act. That the suit was instituted 3 years, 18 days. This 18-day was the delay. No suit can be filed with limitation petition. Section 33 of the Limitation Act. I have the judgments. Secondly,
You submit the judgments.
Lord's. Supreme today.
All these 5 judgments relates to this point.
No, there are other points also.
Okay. Which judgment is relevant here?
Relevant. It is specific. Article 54 specifically pack 16C agreement to sell.
Mm.
For specific limitation under Article 54 of Limitation Act for specific performance of a contract would be 3 years from the date from which specific performance, if no date is fixed, when the plaintiff had noticed that the performance is refused, that she had the notice on 1910 as per Exhibit 2.
Mm.
As per Exhibit 2.
Mm.
She had the notice that we refuse to execute the final sale deed, 1910.
Mm.
Lordship, that has to be marked. First take is equivalent to 1910, 2010, 2007. Because then in that case, I'll give you, because these dates we have taken it from Panjika as well as Google Map.
Mm.
Because I'll give I have converted table, I have brought it, give it to Honorable Court. So, another judgment is there. So, there can be no second thing that suit can be filed beyond 3 years under Article 54 of the Limitation Act. The second judgment also relates to the same rejection of plaint. Even if this plea of limitation is not taken by either parties, but generally defendant, it is a defendant's plea brought by limitation. Even if the defendant fails to take the plea of limitation, even then it is a duty of the court, honorable court, to take into notice of the point of limitation.
Mm.
If I am clear on this point of limitation, Lordship.
Mm.
Then my next point of argument will be specific relief act. This center suit is related based upon the specific relief act.
Mm.
Specific relief act was amended in the year 2018 by Act of 2018.
Mm.
So we got to have 2 acts of specific relief act prior to 2018 and specific relief act after 2018. The old act says there are many provisions of old act was amended. Section 9, 10, 12, 14, 15. And our address is a section 20. What section 20 says? The new act does not say what is section 20. What section 20 and old act section 20 is different. Old act is discretion of the discretion as to decreeing a specific performance, whereas new act says substitute performance of contract. So this case, I have the judgment along with that. In this case, it is not going to apply retrospectively. This case will apply prospectively. That means we are going to be governed by the old act. Prior to 2018 amendment. Discretion as to this decreeing a specific performance. This jurisdiction of decree of specific performance is discretionary and the court is not bound to grant specific relief merely because it is lawful to do so. But the discretion of the court is not arbitrary but sound and reasonable, guided by judicial principle and capable of correction by the Court of Appeal. The following are the cases. There are a number. The following cases which the court may properly exercise the discretion to the degree of specific performance. Where the terms of the contract or the conduct of the parties at the time of entering the contract or other circumstances under which contract was entered are such that the contract, though not voidable, gives plaintiff an unfair advantage over the defendant. This is very important.
Mm.
Because we have the records before the Honorable Court that the plaintiff not only instituted the suit on the basis of the sale agreement and on the same day executed another sale deed in respect of adjacent plot of land. And in this plot of land, the defendants and their families have been residing. This is the only place of residence for them now. Second, whether performance of the contract would involve some hardship on the defendant which he did not foresee, whereas non-performance would involve no such hardship on the plaintiff. Here is exactly, plaintiff have already got 1 lakh, 1 kotha 3 lesa land, registered deed
Mm.
on the same day.
Mm.
C, where the defendant entered into contract under circumstances which, though not rendering contract voidable unless makes it inequitable to enforce the specific performance. Here in the case again, if in the case of this performance is allowed,
Mm.
the defendant and their legal heirs will suffer now. Because there is no evidence to show that they have other elsewhere land anywhere. And there are documents to show that they have been residing in a submerged plot of land in our, when the respondent filed the application under Order 39 Rule 1 and 2. It shows that we have been residing in the plot of all residential houses, though the schedule of the plaint, schedule of the sale agreement, that is Exhibit 1, does not contain any such description of residential houses.
Mm.
So therefore, even if his court has the full discretion, and in the year before the amendment of 2018, in a case of specific performance of contract, not only specific performance is to be paid, there has to be an alternative relief also. In the case of present plaint, there was no such alternative relief. Alternative has to be pleaded. It was a condition precedence. In the case of, if the Honorable Court comes to the, what is that called, plaint did not contain any such alternative relief. Alternative is what? In the present case, even let us, when the suit itself is barred by law of limitation, the question of other things by second submission does not come into play. But as an utmost caution, I've taken the second plea that this is a case where this Honorable Court has the discretion to see that the present plaintiffs, present appellants does not suffer any hardship, because it is seen that they are going to suffer hardship. 1 kotha 3 lesa was sold for merely 40,000 rupees, and remaining 1 kotha 8 lesa, where they have been living since the time of their predecessors, is going to be handed over to the respondent. And this Act of 1818 has no retrospective effect. It is a prospective. This judgment contains, one of the judgment contains that also, that proviso also, that provision also. Lordship, if
Will you resume after 5 minutes?
Lordship. Then prior to amendment.
Earlier section was a discretion as to
Dis-
declaring specific performance.
Yes, Lordship.
Hmm.
So we are covered by this section that the court has the discretion decreeing the specific performance. That means these are the 3 conditions where court can use its discretionary power. Not necessary specific performance has to be given. And I am covered by that, because there are 2 plots of land. One was without any construction, that they have already taken it by way of registered sale deed on the same day, 1 kotha 3 lesa, for a mere amount of 40,000 rupees. And another one, this present one, 1 kotha 8 lesa, for 2,24,000.
Mm.
Where we have been living with our family. The present appellants are living with their family. And that is the subject matter of the, where they have filed their petition in limit, what is it called? IA. In the IA, they sought injunction.
So which judgment you have relied upon in this matter?
Judgment,
In respect of section 20 of the old law?
yes, Lordship. That is reference made to the Honorable Court of Apex Court Judgment 2023 1 SCC 355. Kata Sujata Reddy versus another. Here it is specifically stated that yes,
No, you have not given that judgment. Oh, the later one.
later on that is,
Okay. 2024,
Your Lordship,
20 SSA 140.
Your Lordship. Here it is stated.
Which paragraph?
Yes. Oh. Kata Sujata Judgment was. What I said, please. What to do? What to do? Yes, I do. That is a page. Page will be different because that one. 13 para. Section 10 of specifically not procedural but substantive. Section 20, 2020. Amendment to the provision does not apply retrospectively in pending cases, pending proceedings.
Where it is stated?
It is stated 13. This court also held that the following on merits, the section 10 of specifically is not procedural but substantive, that the section 20 of amendment to the provision does not apply retrospectively to the pending proceedings.
Hmm.
So our old act will be applicable. It is not it is prospective, not retrospective.
Okay.
Therefore,
Hmm.
the appellants are entitled to get the provisions of benefits of section 20 of the old act. That is discretion of the honorable court. On the point of discretion, I like to submit that the appellants have the only place of residence now. They don't have any of this separate residential plot. The other plot is already sold to them, sold to the respondent. And that they have been residing there is already decided by this, because they are on their application under order 39 rule 1 and 2, that they filed a application stating that we have been renovating the suit property, which changes the natural character of the suit property. The respondent will not suffer any losses. At best, if I am not covered under Article, first of all, I am already covered by under Article 54 of the Limitation Act. In the event, in the event that point is decided against me, still I am protected under Article 20 of the Specific Relief Act. Lordship, I have that conversion table, Google, as well as the Panjika, because to show that the dates equivalent, the corresponding dates, Bengali era to English era, Gregorian era.
Okay.
Because
So, you say, now we have to answer two substantial question of law. One is framed on 12/7/2017.
Lordship,
Whether the court below was correct in applying the discretion or decreeing the suit for specific performance of contract on
Lordship,
the face of stipulation made in the Exhibit 1, the alleged agreement for sale. And number 2, whether the impugned judgment and decree passed by the learned courts below suffers from perversity for non-consideration of the point of limitation while deciding the title suit number 57 of 2010 and title appeal number 06 of 2015. While such a plea was taken by the appellant in a written statement. So these are the two substantial question of law.
Lordship.
Okay. Yes, Mr. Day.
Wait. My lord. My learned friend has read the Exhibit 1, my lord.
Mm.
My lord. There is two parts in the agreement for sale.
Mm.
My learned friend, first part read, the second part has not been.
Mm.
There is a condition, my lord.
Mm.
But I may be allowed to read the whole
Mm.
agreement, my lord.
Mm.
প্রথম পক্ষ শ্রীমতী মাধবী মজুমদার, স্বামী শ্রী হরি মজুমদার, জাতি সহিংস। দ্বিতীয় পক্ষ শ্রী পঙ্কজ কুমার দাস, পিতা মৃত সহিংস। Then কস্য মাটি বিক্রি বায়নাপত্র পত্র বিদং কার্যজ্ঞানে যেহেতু মোর পক্ষর হক সত্তর দলীয় নিম্ন তপশিল বর্ণিত মোট 1 কোটা 8 লেসা মাটি প্রথম পক্ষর শর্ত সাপেক্ষে বিক্রি করিম বলি প্রকাশ করাত আৰু প্রথম পক্ষ উক্ত চুক্তিত আগ্রহী হওয়াত উক্ত মাটির মূল্য 2,24,000 টাকা বন্দোবস্ত ক্রমে আজি ফাইনা বাবদ নগদ ৯৫,০০০ টকা প্রথম পক্ষর পৰা দ্বিতীয় পক্ষই সন্ধি পাই স্বীকার কৰিছে। দ্বিতীয় পক্ষই উক্ত প্রথম পক্ষর বাইনাকৃত টকা চলিত বাংলা মাহৰ আহিন মাহৰ ৩০ তাৰিখৰ ভিতৰত দ্বিতীয় পক্ষ ঘূৰাই দিলে কন্ডিশন ৩০ তাৰিখৰ ভিতৰত দ্বিতীয় পক্ষই ঘূৰাই দিলে প্ৰথম পক্ষৰ কোনো ওজৰ আপত্তি নকৰাকৈ উক্ত বাইনাকৃত টকা ঘূৰাই ল'ব বা ঘূৰাই ল'বলৈ বাধ্য থাকিব। আৰু উক্ত টকা আহিন মাহৰ ৩০ তাৰিখৰ ভিতৰত উক্ত টকা ৩০ মাহৰ আহিন মাহৰ ৩০ তাৰিখৰ ভিতৰত দ্বিতীয় পক্ষই প্ৰথম পক্ষৰ বাইনাকৃত টকা ঘূৰাই দিব নোৱাৰিলে চলিত বাংলা মাহৰ পুহ মাহৰ চলিত বাংলা চনৰ পুহ মাহ পৌষ মাৰ্চ দিস ইজ ইম্পৰ্টেণ্ট। পুহ মাহৰ ৩০ তাৰিখৰ ভিতৰত বাকী টকা মুঠ ১,২৯,০০০ টকা ২৯,০০০ টকা প্রথম পক্ষই দ্বিতীয় পক্ষক আদায় দি দ্বিতীয় পক্ষৰ কোনো ওজৰ আপত্তি নকৰাকৈ প্রথম পক্ষৰ নামত মাটি বিক্রি সাফ কাওলা হোজাই উপ পঞ্জীয়ন কার্যালয়ত গৈ রেজিস্টার সম্পাদন কৰি দিবলৈ বাধ্য থাকিব। প্ৰথম পক্ষই অৱশিষ্ট টকা নলৈ তাল বাহানা কৰিলে বা প্ৰথম পক্ষই ম্যাদৰ ভিতৰত বাইনাকৃত টকা গ্ৰহণ নকৰি তাল বাহানা কৰিলে প্ৰথম পক্ষ বা দ্বিতীয় পক্ষৰ টকা আদালতত জমা দি অপৰ পক্ষৰ পৰা মুক্ত হ'ব। দ্বিতীয় পক্ষৰ ম্যাদ অন্ত হলে প্রথম পক্ষৰ পৰা অৱশিষ্ট টকা লৈ অসুবিধা কৰিলে প্ৰথম পক্ষই আইনৰ আশ্ৰয় লৈ মাটি পাব লগা হলে প্ৰথম পক্ষৰ ক্ষতিপূৰণ দ্বিতীয় পক্ষই বহন কৰিব লাগিব। তাত আমাৰ উভয় পক্ষৰ কোনো ওজৰ আপত্তি নাই বা নকৰো বা আমাৰ ৱাৰিছে কোনো প্ৰকাৰ ওজৰ আপত্তি কৰিলে দাবী দাবা কৰিলে কৰিব নোৱাৰিব, কৰিলে মিছা অগ্ৰাহ্য হ'ব। স্বইচ্ছাই স্বজ্ঞানে স্থিৰ বুদ্ধিত দ্বিতীয় পক্ষই প্ৰথম পক্ষৰ পৰা টকা নগদ চমজি পাই এই মাটি বিক্রির বাইনানামা পত্র লিখি দিল ২৬ তারিখ ২০০৮। জিলা নগাঁও লাস্ট ইম্পর্টেন্ট লাস্ট লাইন আফটার শিডিউল যে প্রকাশ থাকে যে লাস্ট টু লাইন্স প্রকাশ থাকে যে মোট দখলপথে পরিমাণ কম বেশি হলে টকার পরিমাণ কম বেশি হব। So, in this case, agreement was signed on 26/4/2007. That is equivalent to 12 Boishak Bangla 2014 BS. 12th Boishak. Defendant has to pay it within 30th Ashin BS 14. So equivalent to 16th October 2007. Then defendant to perform and hand over the possession within 30th post of the day. If the defendant failed to 30 তারিখৰ ভিতৰত টকা ঘূৰাই দিয়ে, my lord, condition to this is the condition, my lord, যে পুহ মাহৰ 30 তাৰিখৰ ভিতৰত যদি টকাখিনি দিব নোৱাৰে তেনেহলে বাকি টকাখিনি প্লেন্টিফে তেওঁক দিলে তেওঁ ৰেজিষ্টাৰ কৰি দিব। যেতিয়া এইটো condition that suppose if this issue has been dealt by the courts below, trial court as well as the appellate court also. My lord, that 30th proof, this is the turning point. If within that 30 ভিতৰত বাকী টকা 1,29,000 টকা প্ৰথম পক্ষই দ্বিতীয় পক্ষক আদায় দিলে প্ৰথম পক্ষই দ্বিতীয় পক্ষই কোনো ওজৰ আপত্তি নকৰাকৈ after expiry of the 30 days they have not returned that the 30th Ashin they cannot return it. So after 30th post the plaintiff has offered the amount 1,29,000 and they requested him to register the sale deed. But they failed. That is, cause of action arise after refusal and the legal notice is given in this regard subsequently. That means within 30th post, that means 15th January 2008, this is the last date to return the money by plaintiff to the defendant. But defendant refused on 15th January. Then it is, the case was filed on 8/11/2010. That is within the limitation from the date of refusal. But the last date is 15/1/2011.
No, in the legal notice, you see this para number 3 of the legal notice dated 26/11/2009.
9.
That is,
So-
the refusal come with effect from 1st of Kartik 1414 Bengali era.
My lord, this legal notice is given 26/11/2009.
Yes.
This is subsequently, my lord, but in the meantime, my lord, two thousand eight, 15th January 2008 was the date of return of the money. 30th post,
Mm.
that is 15th January 2008.
15?
30th post is 15th January 2008. So, and the 15th January is the last date to, that is to return the money. And the plaintiff has offered the amount and requested him that you register, you have failed the, return the money, so I have returned the balance amount to you, so you register the thing. That was not, my lord, complied with. Thereafter, this
No,
notice
no,
has been given.
you see in paragraph number 3, it is mentioned that 1st of Kartik of 1414 Bengali era.
30th post, that is 15th January, as per I calendar I have given.
No, this 1st of Kartik.
Kartik is not mentioned there, my lord. Kartik, what
No, it is mentioned in your legal notice,
legal notice, Kartik?
prayer number 3, exhibit 2.
Where is it? On and from first day of Kartik 1414, Bengali era might say the client approached you many a times to accept the rest amount. 1,29,000 and requested you to execute the final sale deed. Final sale deed as per the terms and conditions of the agreement.
Mm.
1440 Kartik, my lord, this is on and from, this is the refusal.
Mm.
My client has given this notice that on and from the first day of Kartik, Bengali era,
Mm.
my said client approached you
Mm.
many times.
Mm.
My lord, next para, or
Mm.
as per the terms and condition of the said agreement, you are legally bound to execute the sale deed in favor of my said client within 30th post 1414. Bengali era, but you are intentionally avoiding to execute the final sale deed with a malafide intention to have a wrongful gain. So, my lord, within 30th post, they are bound to execute the sale deed, my lord. This is the last limit given by the as per the agreement. But that has not been done. Earlier, this is Kartik, my lord. He has to supposed to return within Ashim, 30th Ashim. That has not been returned, the defendant. So, if verbally give a demand, they you pay. Otherwise, I will pay you the rest amount. So, rest amount offered in post, 30th post. My lord, it will be clear, my lord, from the judgment. It is clearly dealt with by the court below, my lord.
Okay.
My lord, can you see? The issue and the findings. Yeah.
Of which
Trial
judgment?
court judgment, my lord, page 19 of the memo, 2nd April, my lord.
Which paragraph?
Paragraph, page number, my lord. Sure. 24 page. My lord, issue number 3 and 4. May I read, my lord?
No, that is not in respect of limitation point.
My lord.
That is not in respect of limitation because in respect of limitation, no
my-
issue was framed.
Yes. My lord, limitation, my lord, kindly see there whether they have raised any point in their WS. Only point, my lord, WS kindly see page 59.
Page 59.
Page 59. They have generally stated that this
No, no,
suit is barred by
no. This point number 3 is there that the suit is barred by the law of limitation.
limitation.
Yes.
They have not given any pleadings. Why, how it is barred by limitation? They have to give
No,
the
they have
pleadings.
taken the
If-
plea.
My lord,
They have taken the plea.
they have taken the plea barred by limitation.
Then
Then they have to plead how it is barred by limitation.
the
Where are the
court.
pleadings? my
No,
lord?
no.
Nothing.
No issue was framed on that point.
My lord, if the pleadings are there that due to these reasons it is barred by limitation, then issue should be framed. Otherwise, mayor saying that barred by limitation, no, how issue will be framed, my lord? There is no pleadings in the WS. And in this regard, my lord,
Yes,
I
a
like to bring
statement
one
statement is
citation, my
there.
lord, that if limitation pleads to be taken, pleadings should be given, my lord. Why it is barred by limitation? There is no pleading. So issue has not been framed, my lord.
No, is it not part of the pleading? Paragraph number 3.
My lord, decision mechanically taken, technically taken, this is barred by limitation. May I
No,
read
even
my
though
lord?
it is sufficient to frame an issue.
Why have not, they have never.
No, no.
argued this
Is
point.
it not sufficient to frame one issue on this point?
My lord, my humble submission, if it is barred by limitation, they should argue the matter before the trial court as well as the appellate court also. They never
No,
argue
no.
this point.
Unless the issue is framed, why should they argue? It is your burden to establish that suit is not barred by the law. Of
Yes, my
limitation.
lord, as per my lord's agreement, this suit is not barred by limitation.
Mm.
And there is no pleadings in the WS also.
Mm.
That due to this reason, it is barred by limitation.
Mm.
If your lordship gone through the entire agreement and the issue dealt with,
Mm.
it is within the limitation period.
Mm.
It is within the limitation period. And moreover, my lord, they have not taken specifically anything that from the refuse date of limitation starts from the date of refusal of the my lord, performance. Refusal of the performance. Where it is refused, my lord, this is 30th post subsequently given demand that you they either take the money or register the agreement.
No, in
Same.
your, no, in the legal notice, it is clearly mentioned that on and from 1st of Kartik 1414,
So, yeah.
Bengali era.
My lord, this is with respect to because they are to return the money within 30th Ashir.
Mm,
3 মাহৰ 30 তাৰিখৰ ভিতৰত দ্বিতীয় পক্ষই প্ৰথম পক্ষক বায়নাকৃত টকা ঘূৰাই দিলে দিব নোৱাৰিলে
mm,
চলিত মাহৰ বাংলা মাহৰ পৌষ মাহৰ 30 তাৰিখৰ ভিতৰত বাকী টকাখিনি 1,29,000 টকা প্ৰথম পক্ষই দ্বিতীয় পক্ষক আদায় দিলে দ্বিতীয় পক্ষই কোনো ওজৰ আপত্তি নকৰাকৈ প্ৰথম পক্ষৰ নামত মাটি বিক্ৰী সাত তলা বুজাই উপস্থিত কাৰ্যালয়ত ৰেজিষ্টাৰ কৰি সম্পাদন কৰি দিব।
mm,
That means, my lord, this is the 30th. Akin is the last date to defendant took the money is to return to the plaintiff.
mm,
If he failed within 30th Akin,
mm,
then another condition is that within 30th post,
mm.
plaintiff has to given the balance amount to him. And on that event, defendant will register the land in favor of the plaintiff.
Mm. On which date you have offered the remaining amount?
The remaining amount, my lord, he requested on from the day of Kartik. Because see, last day, 30th Ashim,
Mm,
the defendant has to return the money,
mm,
advance money. If he returns,
mm,
plaintiff will accept it. And the matter is there.
mm,
No agreement, no sale cost. But that has not been done by the defendant
mm,
within 30th time. So, from first day of Kartik,
mm,
plaintiff demanded from
Mm.
the defendant
mm,
that you give the money, otherwise
mm,
you register.
mm.
So that is not the date of cause of action. That is not the date cause of action. It is two part. 30th Ahin is the last date given to the defendant to return the advance money to the
Mm.
plaintiff.
No, Mr. Day, you see, in the agreement, the date is written as 38th of Post of 14 Bengali era. And on the very next day, you have approached him to accept the remaining amount and to execute the sale date. But the other side has refused.
My lord, other here the two conditions. Number one,
Mm,
defendant took 95,000 advance. The remaining 1,29,000 is to be given
mm,
within 30th Ashin.
mm,
If within 30th Ashin, the remaining advance money is given, returned to the plaintiff,
mm,
then matter ends there.
mm,
And if defendant fail
mm,
to return the advance money within 30th Ashin,
mm,
then plaintiff has to deposit, given him the remaining balance amount 1,29,000 to the defendant.
mm,
And in that event, defendant has to register the land in favor of the plaintiff.
mm.
So 30th post is the last date to return the money and to give the money by the plaintiff to the defendant. And thereafter, if defendant fail to accept the money, then cause of action arises. Because this is the last date to give the money, offer the money to the plaintiff, to the defendant by the
Mm.
plaintiff. So this is the condition. So Up to post 30, my lord, limitation is given that the plaintiff has to return the money, balance money to the defendant, and defendant in that even defendant has to register the land in favor of the plaintiff. This is the condition. And when plaintiff failed, the defendant failed to return the advance money within 30th Ashin from Kartik, from the month of Kartik, though plaintiff demanded that you have returned the money, advance money, but he has not returned. So on the expiry of 30th post, the plaintiff given the offer that you take the balance amount and register the land in favor of me.
So the cause of action arose from who is that?
From the 30th post,
30th
30th post.
30th post, or from the next date?
yes, my lord. 30th post. This is the refusal limitation.
Mm.
And from 30th post, the plaintiff demanded
No, as per your legal notice, it is the first day of Kartik of 1414.
as per the legal notice, my lord, from the first day of Kartik Bengali era, because 30th Ashin was the last day to return the money by the defendant
Mm.
to the plaintiff. He has not given.
Mm.
So, he actually plaintiff wanted to wanted to take the money, advance money. That if you return the money, return.
You are repeating the same thing.
My lord,
You are not answering my question.
my lord, your lordship question.
Mm. So cause of action arose from which date?
From post 30th post, because that was the date fixed to deposit the balance
No,
amount
as
by the
per
plaintiff.
as per your legal notice, it is first of Kartik.
First of Kartik is a
Hmm?
on and from, my lord.
Mm.
On and from.
Refused.
On and from first day of Kartik Bengali era, my said client approached you many times to accept the rest and final amount of rupees 1,29,000
Mm.
and requested you to execute the final sale deed
Mm.
as per terms and conditions of the agreement. But every time you have refused to do so with some vague pretext, since you failed to return the said advance money received by you within the stipulated period.
Mm.
Then, my lord, kindly see, as per the terms and conditions of the said agreement, you are legally bound to execute the sale deed in favor of my said client within 30th day of post
Mm.
2014. He is bound to execute the sale deed in favor of my client within 30th post 1414 Bengali era. But you are intentionally avoiding to execute the final sale deed with a malevolent intention to have wrongfully. My said client is urgent need of money, so mention schedule of the aforesaid agreement and your reluctance to execute the final sale deed causes a serious mental agony. So, my lord, from the date of refusal, that is 30th post is the last date to return the money. They have not returned, not registered the sale deed. So cause of action arises, my lord, in that. So if we calculate from that date, then my lord, the 30th post is 15th January 2008. It comes
Mm.
15th January 2008, and the case is filed on 8/11. From the date of this last date, my lord, 3 years.
Mm.
8/11/2010 case was filed, my lord.
Mm.
Because the last date was 15/1/2011. 30th January 2008 equivalent to 15/1/2011.
Mm.
And the case was filed on 8/11/2010. 1 year's advance, my lord.
1 year's advance.
My lord. The case was filed in 2010. And the limitation comes 15/1/2011 up to, from the day, if you calculate the refusal from the date of refusal.
No, here date is mentioned. If date is mentioned, then the second part will not come into play. Article 54. The date fixed for performance. Or if no such date is fixed, then only the plaintiff has noticed that performance is refused.
My lord, the date fixed for performance 30th post.
Yes, that is 15th of October 2007.
15th of January 2008.
15th of January,
2008.
is it?
Yes.
Lordship, I rightly understood that thing. The first condition, we did not follow it.
Hmm.
The moment first condition, we did not follow it. Second condition, they ignored it because they already issued notice.
It is
The second condition,
conjoint reading, my lord.
No, Mr. Dev, please.
second conditions, which they could have done it. They deliberately, of their own, they did not abide by it by issuing the legal notice, stating clearly that they approached us on first of Kartik. That is on the date we have refused. The course of action will start from that. Second condition will not come into play. Why? Because by exhibit 2, they already told that we went to you to
No,
repair.
no, in the exhibit 1, date is mentioned.
That is mentioned that by 30th of Asil we have to pay the amount. We could not pay. Whereas our written statement clearly says that we approached them and wanted to pay him. He is neighbor because we are suffering from fever, some problem, ailments. Therefore, they said you pay us back. All those things were never considered in the judgment, both the trial court as well as the first appellate court. Let us not come to the defendant's defense. Only the thing, it is only clearly case was decreed on the point of plaintiff point of view. Plaintiff's point of view only. The plaintiff, all right, first part of the agreement will come into play. Yes, if you pay back the amount, that it will be considered.
Then
All right. If we fail,
then
all right. If we fail, we fail. All right. Assuming that we have failed it.
then second
Now,
condition.
second condition, if the second condition comes to what their document says, because second document says exhibit 2, on which they demanded us that you on 30th of or is it, 1st of Kartik we approached you. Next day they approached us. If that is the exact that is the document both the courts will relied upon. Therefore, we refused it. The moment we refused it, cause of action will start from there, not from 30th, because second condition, they deliberately themselves avoided it. The plaintiff avoided it. Because before that, they have come.
They have also given the legal.
All right, those legal notice will not, our district will not
My
come.
lord, limitation period does not arise in this case because he is confusing, my lord. This
No, no,
my lord.
no, not confusing.
As per
The code,
agreement, it is clear, my lord.
the
As per
code has
agreement, it is
rightly,
clear.
No,
code has rightly
Mr.
understood.
Dev,
it.
you see the Article 54.
The date is fixed. Yes, Article 54, date is fixed.
If you finish, then I can. Otherwise, my lord, it will be chaos.
No, I have asked a question to him. That's why he is responding. You see Article 54. 3 years. The date fixed for the performance. Here date is fixed in exhibit 1 in the agreement. Then from the legal notice also exhibit 2, it appears that they have refused from the first day of Kartik of 1414 Bengali era.
Terms and condition that you are to pay 30th আহিন মাহৰ 30 তাৰিখৰ ভিতৰত দ্বিতীয় পক্ষ ঘূৰাই দিলে প্ৰথম পক্ষই কোনো ওজৰ আপত্তি নকৰাকৈ উক্ত বাইনাতকৃত টকা ঘূৰাই ল'ব।
No, that's all right. On
My lord, it is
within
clear,
that
my lord.
period,
30th আহিন, he has to give the money,
No.
then matter ends there.
he had not
But-
returned it.
But yes, he has not returned it. Then my lord comes second condition. If
Mm.
he fail, what will be the consequence?
Mm.
If he fail, then the condition is that then the second party that the first party has to deposit the balance amount with the 30th post.
Mm,
30th post.
mm,
That I have to deposit
mm,
the balance amount to him
mm,
on 30th post.
mm,
On expiry of 30th post, on the 30th post, I have given demand. Then you take the money and
Mm.
register.
On first of Kartik.
First of Kartik due, my lord, first of Kartik, that means first of Kartik, Ashin, 30th August expire,
Mm.
he failed to pay.
Cause of
Then
action arose from the very
verbally
next
it is-
date.
It is verbally told the dependent that you have not paid
Mm.
the amount, the advance amount within 30th Ashin. So if you did not pay, then he has to deposit the balance amount.
No, you tell me the period of 3 years is to be
3
counted
years
from who is that?
refusal. That means
From the date of refusal. Date of refusal is mentioned in your legal notice as first of Kartik. You see this exhibit 2.
in the legal notice, my lord, and the second paragraph 4.
Mm.
Paragraph 4, kindly see. Paragraph 4.
Mm.
Paragraph 4. As per the terms and conditions of the said agreement, you are legally bound to execute the sale deed in favor of my said client within 30th post
Mm.
1414.
No, that's all right. He has refused. So cause of
30th
action
post-
will arose from who is that?
30th post after liberation, he has to register the sale deed, but he has not. Then cause of action arise, my lord.
Yes. Cause of action arose from who is that?
30th post after expiry of 30th post 1414.
No,
30th
no.
post, 30th post, that is, my lord,
From the first of Kartik.
Kartik, my lord, Kartik, it is a demand that you have Ashin is the last day that you have not, dependent has not returned the money. So
Mm.
from Kartik, the plaintiff
Mm.
asks the defendant that you have, my client has demanded from honor from the day of Kartik, first day of Kartik. They could return the advance amount. What you have not given, so you register the sale deed in favor of the plaintiff on 30th post.
Mm.
So 30th post is the last date, my lord,
Mm.
to register the sale deed in favor of the plaintiff. If the plaintiff given the advance, remaining amount of the
Mm.
consideration.
Mm.
And the 30th post, from 30th post, that means 15th January 2008.
Mm.
And if limitation calculated from 15th January 2008, my lord, 3 years from that point, within 3 years. From starting point, my lord, 30th post, limitation starts from that date for 3 years. And the case was filed in 2010.
But from your own documents, it appears that he refused to accept the amount and execute the final sale deed with effect from first day of Kartik as per your legal notice.
Legal notice, my lord, kindly, this is my lord,
Mm.
on and from day of Kartik, state client approach, my state client approached many times to accept the rest final amount 1,29,000. That means, my lord, within 30 post, he has to deposit the plaintiff. Within 30 post, remaining amount.
Mm.
If defendant fail to deposit, return the advance amount within 30 Tashin, then defendant, plaintiff has to deposit the balance amount within 30th post, my lord.
Mm.
30th post to the defendant. And in that event, defendant has to execute the sale deed.
Mm. Then why did you issue the legal notice?
My lord,
why did you issue the legal notice?
Legal notice, my lord, he has not given the balance amount nor registered the.
Why you have mentioned it as a first day of Kartik, 1414?
30th is the within 30th post the plaintiff has to return give the balance amount to the
No,
defendant.
then why did you issue this legal notice mentioning the date of refusal as first of Kartik?
My lord,
Is it not your document?
it is my document, my lord.
Then
I'm not. My lord, they are also given the reply on that.
Hmm.
They also given the reply. Next one, my lord, exhibit 3.
Hmm.
They have given the reply.
Hmm.
If they have not given any reply, then it's different.
Hmm.
They have given 2 replies, my lord. Exhibit 3 and exhibit 4.
Hmm.
Exhibit 3, my lord, kindly see.
Hmm.
My aforesaid client instruct that is given given by the wife of Pankaj Das.
Hmm.
That Pankaj Das husband, my client is seriously ill. He is suffering from last 12 years in complicated diseases. Not in a position to instruct me personally. So he has instructed through his wife to reply your advocate notice.
Hmm.
That my client, knowing from her husband, instructed me to write you that husband of my client cannot recollect of execution of any registered deed
Hmm.
of agreement dated 26/4/2007
Hmm.
and was a bandhak
Hmm.
and instructed me to request you to aid his memory by
Hmm.
sending a copy of the said deed of agreement to him, and in the meantime he may recover, and thereafter seeing the same he shall reply your advocate's notice satisfactorily.
Hmm.
Then my lord, exhibit 4.
Hmm.
So he has given, this is a registered agreement, my lord.
Hmm.
And now they are denying that registered agreement also.
Hmm.
Well, can they refuse it? Whereas they have identified their signature also in the evidence, my lord.
Hmm.
Can they refuse it that that agreement cannot be recollect? And they kindly see the subsequent, my lord, exhibit 4. Exhibit 4 also given by the Pankaj Kumar Das. This is a reply to the
Hmm.
plaintiff. Under the instructions from and on behalf of my client, Sri Pankaj Chandra Das, son of late Babaranjan Das, resident of Lanka, so and so, so and so. That on 26/4/2007, my client, being urgent need of money, took 95,000 as a loan, and it was agreed that within 30th Ashwin 2014, my client shall return the money, and in default, my client shall have to sell his residential land to you at rupees 2,24,000.
Hmm.
That thereafter, within 3 months and the subsequent thereto, within 30th Ashwin, my client tendered you the money. But on this and that effect, you have not accepted the money, and consequently, by your acts, the stipulated time passed. Yet my client is ready with money to pay you, and my client is ready to pay interest at admissible rate. Under circumstances, I have been duly instructed to my client to request you to accept the money as aforesaid, and whenever you tell my client to pay, then and then this will make payment. That means, my lord, he has admitted that the agreement was there, but he, by this exhibit 4, he admit that I have offered I have offered, returned the advance amount to you, but you have not taken. So the blame is given to the plaintiff that he has not accepted the return amount,
Mm,
advance amount.
mm,
This is not correct, my lord. So, my lord, what is main thing is that, my lord, that the agreement and the terms and condition is there. Once the defendant, my lord, defendant entered into a registered agreement and subsequently they are saying that there is no registered agreement and thereafter saying that another
no,
agreement, yes,
Mr. Day, you say, to appreciate that kind of argument, this court has to appreciate the evidence,
my lord,
which this court is not entitled to, sitting in second appeal.
my lord, his contention is limitation. Number one, limitation. Number two, hardship.
Mm,
Hardship here is not, there is no substantial question, my lord. Is
mm,
So, first question is, substantial question is only limitation.
mm,
Now, the limitation, my lord, limitation, his contention is that from the date of Kartik, first Kartik limitation start. My submission is that not the Kartik limitation starts from 30th post
mm.
because it is the last date fixed to return the balance amount to
No,
the plan, to the
if
defendant.
that is the factual position, why you have issued this legal notice mentioning therein that the amount was offered on 1st of Kartik and he refused?
This is my lord with respect to advance money. He requested the advance with respect to advance money because on the Ashin Kartik, first Kartik, that means 30th expired, 30th date expired to return the advance money to the plaintiff.
Mm,
Defendant did not. So on the next day, reminder is given that you have not given the advance money. I plaintiff approached you, but you have not returned the money. Approach you many times and accept the rest final amount.
mm,
So final amount yes to demand, my lord. This is correct, my lord. Final amount is to be
mm,
deposited within 30th post, my lord.
mm,
So within 30th post, he has offered the balance amount.
mm.
Up to limited 30th is the last date.
Mm.
30th post. Then you are to
Okay.
deposit the balance
Whether
amount. Okay.
this translated copy of this agreement, Exhibit 1 is available on the record?
No, it is not
No.
on record. The Honorable Court feels it that it needs to be translated. We'll give a copy.
On next that furnish it, we'll keep the matter as part heard.
All right.
Heard Mr. Bhagavati, learned counsel for the appellant. And also heard Mr. Day, learned counsel for the respondent. List the matter on COVID. Before. Second appeal for further consideration. And in the meantime, both the parties shall produce before this court the translated copy of the Exhibit 1, the agreement for sale.
Okay.
May I please lordship?
This Ponjika and the
I'll
start
let it
you may
in the record.
record.
May I please lordship? Lordship, my lord, item number 18 and 19. Analogous case.
Item number?
2 in the meantime expired.
Item number
18 and 20. Sorry, 18 and 19. 18 and 20. So I'm the applicant, my senior. Hello.
and
So we have filed an amended memorandum of regular second appeal. My lord, here is respondent number 2, Dhiren Chandra Kolita, in the meantime expired. So need to file substitution petition. Because they will be
item number
item number 18
and 19.
18 and 19.
Yes, my lord.
You are for the?
I'm the appellant
I'm
myself.
for the appellant, my lord.
Okay.
The respondent has today informed us that the respondent
Number
number
2.
2, Dhiren Chandra Kolita, has expired. So now it would be required of his substitution.
Okay.
So,
Respondent number 2 suffered demise.
Yes.
Yes.
Okay. Heard in 18, item number 18, heard Mr. B.K. Sharma. And you are also there, Mr. Pal.
I'm assisting advocate.
Okay.
Appellant.
Learned counsel for the appellant and Mr. Sharma for the respondent. Respondent. Mr. B.K. Sharma, learned counsel for the appellant, submits that the respondent number. You are for respondent number?
Respondent number 2,
2.
No.
I'm the appellant, my lord.
Dhiren Chandra Kolita, is stated to have been expired.
You are for the respondent number 2.
No. All sole respondent. Mr. Sharma is sole respondent. I'm behalf of the appellant, my lord.
You are in item number 19.
Both items.
Both
item.
items,
Okay.
both parties are same.
No, this is respondent number 2, Hiren Chandra Kolita.
Yes,
He died.
he died.
He is respondent number 2.
2.
No, if you are for the respondent number 2,
No.
No,
They-
we are
he
for
is-
appellant, my lord. The respondent have informed today
all the
that
respondents.
the
Mr. Sharma for all the
respondent-
respondents and Mr. B.K. Sharma, learned counsel for the appellant, submits that the respondent number 2 suffered demise. And as such, his legal representatives are required to be brought on record. And he prays for listening the matter after when?
After view,
After 4 weeks. After 4 weeks.
So he would give us the particulars, my lord,
respondent.
Particulars.
of the,
Okay.
to whom would be
Furnish the
substituted.
particulars to him then.
Because the deceased respondent was the secretary.
Secretary.
So he used to take
In
the
the meantime,
information from his
Mr.
party.
Sharma, learned counsel for the respondent shall file the particulars of legal representative of respondent number 2 to
Yes.
Mr. B.K. Sharma, learned counsel for the appellant. Okay.
In the meantime, my lord, president had also changed my name. In the meantime, there had to be election and president had also changed.
Respondent number 1.
So we shall inform the name of president and new president also.
Okay.
Respondent number had also been changed. So we shall inform the name of new president also.
Okay.
So both are same, my lord. Both are same.
Both parties are there. 96.
Okay. Much obliged.
May I please? But I but I would not fully prepare a case for the for an adjournment.
When can it be listed?
Demand of April 7, 9,
7.
7th April or 9th April. Permission. On 10.
Okay. Heard Mr. Dotto, learned counsel for the petitioner, and Mr. A.C. Sharma, learned senior counsel, assisted by Mr. Learned counsel for the respondent number 4. Respondent number 41. 41. And Mr. Bhattacharya for 2 and 3.
Yes.
2 and 3. Mr. Sharma submits that he is not prepared to argue the matter today and tries for listing the matter on 10th.
10th.
Fair allowed, rest shall list the matter on 10th of April.
Obliged, lordship. Deeply obliged.
We hearing matter, item 17, parliament matter.
May I please? Petitioner is before your lordship, my lord, as against the order dated 21/6/2023, my lord,
Hmm.
which your lordship will find at Annexure 7, my lord. Page 53, my lord.
Hmm.
Allowing that the cross-examination of TW1 should be taken before filing of the evidence and affidavit of the other witnesses, my lord.
Hmm. So admittedly, there is no statutory bar.
Yes, my lord. On the last occasion also, your lordship had rightly said, my lord,
Hmm.
that there is no bar. It is upon the discretion of the court, my lord.
Discretion of the court. But the question is, you say this is civil revision petition. If the trial court exercise its discretion in a particular way, sitting in civil revision, this court cannot substitute its own view with that of the trial court. That is the principle.
Our grievances is there, my lord,
Hmm.
that if that is allowed, my lord,
Hmm.
it will allow the plaintiff, my lord,
To fill up the
to fill up
lacuna.
the laguna, my lord.
But is there
Because the
any?
subsequent witnesses, my lord,
Yes.
they have not even filed their evidence on affidavit, my lord.
Can you show some decision on this point?
Petition, my lord, similar petition, my lord, I tried to find, my lord, I could not find, my lord. Only, my lord, one mention of the Honorable High Court, my lord,
Hmm.
which speaks about the section 138, 135 of the Evidence Act,
Hmm.
and, my lord, the trial court rules, my lord.
Hmm.
Here also, my lord, the circumstances and facts are different, my lord, but it has discussed about this, my lord, section 135 of Evidence Act
Hmm.
and order, my lord, 18(1) and 2, and, my lord, the trial court rules, my lord. And it has held, my lord, that although, my lord, discretion of the, it is, my lord, based upon the discretion of the court, my lord, but the court should also should ensure that the plaintiff does not get an upper hand, my lord, in subsequent, my lord, when they file their subsequent evidence on affidavit, my lord. That is to be, my lord, the court has to ensure that, my lord, that
Hmm.
which is
You
our
are
big
referring to rule order?
which, my lord?
You have referred to one order of the CPC? Order and rule?
Well, order 18, my lord.
Order 18.
Order 18, my lord, rule 1 and 2, my lord.
Order 18, rule 1 and 2.
1, 2 is discussed in that judgment, my lord. Order, there is rule 4 is also its recording of evidence, my lord. In every case, the examination of chief of witness shall be on affidavit and copies thereof shall be supplied to the opposite party by the party who calls him for evidence. Then section 135 of the Evidence Act, my lord.
You have enclosed the
Yes,
appendix
my lord. Guwahati Trial Court,
of the
Guwahati
case management.
Case Management Rules, my lord, I
2007,
have,
Page number 47.
my lord. Page number
There
47.
also, you see the procedure of each witness filing his
Examination in chief and being
in chief
examined.
and being examined in cross or re-examination will continue one after the other. After completion of evidence of the plaintiff side, the defense shall lead evidence likewise. Witnesses after witnesses and the chief examination of each witness being by affidavit and the witness being then cross-examined or re-examined. Mr. Islam, what is your stand here? Rightly. But whether we can ignore the apprehension of the petitioner side that if in a piecemeal manner the examinations are allowed, then is there no chance of any improvement in subsequent evidence in affidavit?
It is not, the law is not said that here. Law is not said that. In the CPC also not said. Even said that rule, management rule, management rule also said that one after one. The management rule says I could say. The procedure says examine the witness one after another. Law says
No, it does not mean that you are not required to file the examination in chief all the witnesses together.
My lord.
Hmm?
If there are, my lord, now 5 witnesses are there. He has only filed the evidence on affidavit of only PW1, my lord. The rest he has not submitted. If all have been submitted, my lord, then, my lord, that is the procedure, my lord, but he has not submitted. But and it was, if your lordship will see annexure 3, my lord, page 38, my lord.
Hmm.
Initially, my lord, after plaintiff is file evidence on affidavit of PW1, and time was on the next date was fixed for, my lord, further evidence, my lord. Then on the next date, my lord, he has filed a petition under trial court rules, my lord, that the cross-examination of PW1 should be done, my lord. And which was, my lord, although we had objected because it will allow him to fill up the lacuna, my lord. And thereafter this impugn order was passed, my lord.
Maybe he is not willing to examine the other witnesses cited in the pleading.
That,
Then
my-
in that case,
in that case, my lord, it will be different, my lord. But if, my lord, because his evidence is not, my lord, it is still not closed, my lord.
hmm,
So even after cross-examination of PW1, my lord, he has still time to file it, my lord, the rest of the witnesses, my lord.
hmm. Let us do one thing. We keep the order reserved. In the meantime, you find out any decision if
Well-
available. For Mr. Parasar, learned counsel for the petitioner, and Mr. Islam for the respondent. Argument concluded, order reserved. Find it within 2-3 days
My lord,
and submit it to the court master.
much over.
Order number 20.
Judgment AC,
Item number 20, I appear for the respondent, my lord.
Why should not we dismiss this matter?
I say, my lord, we should dismiss this matter, my lord.
Okay. None appears for the appellant on call. However, Mr. Sudhuri, learned counsel for the respondent present. On the previous occasion also, the appellant remained absent.
Yes, on the previous occasion, actually, what happened, my lord, I took some time for the purpose of reconstructing my file, because I didn't have the file with me. Then ultimately, I had obtained 35 copies, my lord, and now I'm here. But on that day also, the other side was not there, my lord.
Not present. Good, then we will record your submission.
My lord. It can also record that I have supported the order of the learned appellate court, my lord. And there is no infirmity in the order and substantial questions under which, my lord.
No, not on merit, but on non-prosecution.
My lord.
It appears that having admitted the appeal on 26/7/2010, the same was listed on 13/10/2015, 16/10/2015, and thereafter on 19/2/2016 and today. And the appellant remain absent on 13/10/2015 and 16/10/2016. 15. Mr. Soudhuri submits that on 19/2/2026 also the appellant remain absent without the appellant remain unrepresented. And today also the appellant remain unrepresented. In that view of the matter, this court is constrained to dismiss the appeal for non-prosecution. Registrar shall return the record of the learned trial court forthwith.
I'm deeply obliged.
Number 22.
May please, your lordship. Lordship, better maybe adjourn for the day, lordship, because Mr. BD Deka has some personal difficulties
Who?
today, lordship.
Oh,
BD Deka, lordship.
P Deka,
BD Deka.
BD Deka.
Yes, lordship.
Heard Mr.
M. Das, lordship.
M. Das, learned counsel for the petitioner, Mr. Bakhtiar. For the respondent. Respondent. Mr. Das submits that conducting counsel, Mr.
BD Deka.
BD Deka has some inconvenience today and as such a right for adjournment of the matter for the day. Fair allowed, the matter stands adjourned for the day.
Obliged, lordship.
Especially taking its lots.
Okay. Okay.
30th.
Obliged, lordship.
23.
Sir, may I crave your lordship indulgence, my lord? In respect to your supplementary item number 36, my lord, in that case also I had applied for certified copy of the record that is not yet available to me, my lord. So can that matter be taken up after 2 weeks, my lord?
36.
36, supplementary item number 36, my lord.
On the affair being made by Mr. Sodori, learned counsel for the appellant, recessal is the matter after
2 weeks, my lord.
2 weeks.
My lord. I'm deeply obliged.
Fair allowed.
Item 23.
As per my instruction.
Other side. Absent. PK Das, S. Bora, S. Islam, A. Sodori. 2017 matter. Heard Mr. R.K. Moore, learned counsel for the petitioner. None appears for the respondent on call. List the matter after a week.
Item 24.
I am not the respondent, my lord. But I, some accommodation, my lord, I also take consent, my lord, to make after a view.
Okay.
That we reached,
That. Heard Mr. Your name please?
H.I. Chaudhary. H.I. Chaudhary.
I. Sodori.
H.I. Chaudhary.
H. I. Sodori, learned counsel for the
Petitioner.
appellant.
Appellant, yes. We appellant.
Appellant, and also heard Mr. Talukdar, learned counsel for the respondent. Mr. Talukdar, with consent from the other side, pass for listing the matter after
View, my lord.
after
Mm,
BU
the- the-
vacation.
the-
Fair allowed, recess list the matter immediately after reopening of the BU vacation.
21st. of April. 21st. Obliged. Obliged.
25.
The matter may be passed off for the time being. Lordship, my senior is on his way.
Item 26.
Well, I am for the appellant. The respondent side.
Heard Mr. MSek, learned counsel for the appellant. None appears for the respondent or on call. List the matter after 1 week or 2 weeks.
After 2 weeks, madam.
After 2 weeks.
27.
My lord, kindly pass over the matter for time being.
Time being.
Kindly pass over for this time being.
Our list is about to over.
He is on legs actually, Mr. A.K. Gupta.
28. Okay.
Sorry, my lord, I have one prayer, my lord. With item 26. I have repeatedly taking adjournments on avoid courts, my lord.
Item
22. 26, sorry, 26. And my lord.
no. He appeared. And we adjourned the matter as because you were absent here. He has not paid for adjournment.
I did not be like 26.
Hmm.
26.
Mhm.
Possible for.
Pardon?
Yeah, possible.
No. He has already left.
That is the problem.
Hmm. Next item.
29.
May I please, your lordship? May I be protected to this accommodation?
Today.
Actually,
Otherwise, I am not troubling my senior friend because I am having a stay upon the decree. So I don't have any
No.
objection to the prayer.
due to oversight, please.
Okay. Heard Mr. D. Chakraborty, learned counsel for the appellant, and Mr. C. Borua, learned counsel for all the respondents.
No, one and
and two.
one and two.
One and two. One and two. Mr. Borua submits that due to oversight, he could not prepare the matter, and he prays for listing the matter after
After 2 weeks.
after 2 weeks.
Let it, my lord, be after Bihu vacation, my lord.
Okay.
Very easy.
Okay, after BU vacation. We are allowed. This is the matter after BU vacation.
My lord is not fixing any date, my lord. My lord, let it be as it is. Apply.
May it please your lordship, matter may be passed over for the day.
For the day.
Yes, lordship.
Miss, your name please?
S. Ahmed, on the
S.
behalf of R.
Ahmed, learned
Chaudhary.
counsel appearing on behalf of
R. Chaudhary.
R. Chaudhary, learned counsel for the appellant. Prays for adjournment of the matter for the day. We are allowed. The matter stands over for the day.
Lordship. Of list.
May it please your lordship. Lordship, in this matter, the respondent number 1 has filed an affidavit. We seek 2 weeks' time to file a reply, lordship.
When the affidavit was filed? When the affidavit was filed?
6 to
Number.
2.
Okay. 6th of February 2006. 6th of February. Okay. Heard, Mr.
H.N.
Learned counsel appearing on behalf of
M.K. Chaudhary.
M.K. Chaudhary, learned counsel for the appellant, and also heard, Mr. Your name, please?
STR Rasul for 1 and 2, Mithun Vikas Chaudhary on behalf of
The learned counsel appearing on behalf of Mr. M.K. Chaudhary, learned counsel for the appellant, submits that the respondent number 1 and 2.
1 and 2.
1 and 2 have filed
for 3.
an affidavit, and the appellant will file a reply to the same. And he prays for granting.
Lordship, 2 and 3 have not filed an affidavit. Respondent number 2 and 3 have not filed an affidavit.
No, this is RSA. Whether filing of affidavit is necessary.
True, my lord. Your lordship is very correct. In fact, it is based on the available pleadings.
Yes.
But my senior friend has filed one, So there might be some reason for us to afford a reply to the affidavit filed by respondent number 1.
No, okay, you file it.
My lord, my lord.
That is, my lord, if I may speak, that is on the IA. They, at the last stage, they requested that we should go to the main case. So if the main case is decided, the IA does not matter. It becomes irrelevant. So, Muhammad Commissioner.
Okay, we'll fix the next date. In the meantime, they may file their affidavit if necessary, if they wish. And price for price for granting. After 2 weeks, they are allowed. Recessal is the matter after 2 weeks. On next date, an endeavor will be made to dispose of the IS and the RSA together.
Here.
Obligation, Lordship.
35.
Yeah, in this matter, Lordship, last occasion, they sought for time for filing an additional and more substantial question of law. And they have, just now I have received the copy at 2 p.m. Lordship, and second half.
None appears for the appellant on call. However, Mr.
T. Gogoi, Lordship.
T. Gogoi, learned counsel for the respondent present. Place the matter after a week.
Lordship, after the litigation,
No, this is a 2012 matter.
Lordship, no.
Very old.
The Lordship, that may be fixed, Lordship.
Okay. After 2 weeks. That.
11.
At
25.
in the event of subsequent non-representation of the appellant, that order shall fall.
Wait, please, Lordship.
Yes.
Lordship, appeal has been admitted on 16/12/2019. On two substantial question of law, whether finding of the learned trial court as well as learned appellate court in respect of Exhibit C is perverse, as same has been without challenging the sale deed and power of vendor or Prabodhalder to sell the land and without making the said vendor as a party defendant in the suit. That is first. Whether plaintiff respondent is entitled for a decree in respect of 3 quarters of land when, as per Jamamundi Exhibit 10, his vendor had no title and position in respect of 3 quarters of land. These are the two substitution of law.
Whether the second question is a substantial question of law.
Lordship, because it has a material bearing in the case. When a question of law become a material bearing on the case, that is a substitution of law. Because as per evidence on record, Exhibit 10, the Jamamundi of the proper duck says only they have a title in respect of less than 3 quarters of land, 3 quarters and 10 lesses of land. But decree has been given for 3 quarters of land. I will place the judgment of that.
You say to decide this question, we have to appreciate the evidence which is not permissible.
Appreciation of evidence is not permissible in second appeal, but only question is when a evidence or when a finding is contrary to the evidence on record, that is finding is perverse finding, because Exhibit 10
No,
says,
that's all right. On the ground of perversity, that may be a substantial question of law. There is no doubt about it. Okay.
the fact of the case is like this also. My vendor, as well as vendor of the respondent's mother, has purchased land in respect of a plot of land where there is 4 kothas, 10 lesses of land belong to one Gaurangapada Ghosh, where from vendor of the plaintiff has purchased 3 kathas of land, and my vendor has purchased 1 katha 10 lakhs of land. I will place the fact actually in fact. Gauranga Ghosh has some land. He sell the land to Goridas and Prabodh Haloi by 2 registered children. Thereafter, Lordship, the Prabodh Haloi sell the land to me, that is defendant number 1. 1 katha of land out of 1 katha 10 lakhs of land. And Goridas purchased 3 kathas of land from the same vendor. And Goridas died. And thereafter, land has been mutated in the name of son and daughter, from which the plaintiff has purchased 3 kathas of land. Thereafter, the Goridas daughter and son sold the land to the plaintiff 3 kathas of land. And in the present suit, they have claimed that they are entitled for a decree and confirmation of position in respect of 3 kathas of land which they have purchased from performer respondent number 2 and 3. May I take your lordship to the plain first? In the original record. In this suit, lordship, they have not challenged my sale deed, which has been executed by vendor Prabodh Haloi.
They have not challenged?
My sale deed, by which I have purchased 1 katha of land from my vendor Prabodh Haloi. Prabodh Haloi was not made party in this suit filed by them. Prabodh Haloi has not been made a party in the suit, and my sale deed for purchasing 1 katha of land has not been challenged. Lordship will find the plain, lordship to the plain type of the trial court record.
Okay, the plaintiff is also annexed here as Annexer 1
Lordship.
in the second appeal. You are referring to the plaintiff?
Page 10.
Yes, there's that.
Page 10 is a Jalekha Khatun, is a plaintiff. Now I will take a lordship to the prayer portion. What relief they have raised? Page 16. Declaring right at land of the plaintiff over the suit land for recovery of khas position of the scheduled plot of land by evicting the defendant number 1 and its all men, employees, agents, etc. by removing all structure of the defendant number 1. C. Permanent injunction restraining the defendant number 1 from entering into the scheduled land and making any further construction over the plot of land, from transferring the scheduled land to in any manner, or from changing nature and character of the same. Any other reliefs which plaintiff is bound to be entitled under the law and equity. And schedule of land is 3 kathas of land covered by DAG number 35, 172, new KP Pata number 4 of village Nathboma under Moja Beltola, which they have purchased from Lordship performer defendant number Gauranga Ghosh and Gautam Kumar Das and Kakoli Das. That is defendant number 2 and 3. They have not contested the case nor filed this statement in the case, and they are not adducing evidence of Gautam Das or Kakoli Das in the suit. Now I'll take you to my defense.
No, the plaintiff has purchased the land from
Lordship defendant number 2 and 3.
2 and 3.
And I have been made.
And who is this defendant number 1?
Defendant number 1 has been made party, alleging that I possess the land of Gautam Kumar Das and Kakoli Das as a caretaker.
Gautam Kumar Das and Kakoli Das are caretaker.
No.
This,
Gautam Kumar Das and
respondent
Kakoli
number
Das are the vendor of plaintiff in respect of 3 katha of land. Gautam Kumar Das and Kakoli Das sold land, 3 kathas of land to Jalekha Khatun by registered children. They allege that Gautam Kumar Das and Kakoli Das keep me as a caretaker in the suit land. That is why I have been made defendant.
Okay. So you are the caretaker.
Caretaker.
According to them.
According to them. May I read, Lordship, the first paragraph Plaintiff and defendant both are resident of the aforesaid locality in Nadboma, Moja, Beltola. Plaintiff is the owner of a plot of land measuring 3 quarter covered by Doug number 35 old, 117 new, KP Pata number 4, village Nadboma, Moja, Beltola. It is said plot of it is more fully described in the schedule A below. That is 3 quarters of land. And para 2, defendant number 1 was a caretaker, carpenter by profession, and he was engaged in construction of house over the suit land by the mother of the defendant number 2 and 3. Mother of the defendant number 2, 3 had also entrusted the said person to look after the said land as caretaker. Defendant number 1 was looking after the suit land as a caretaker by residing over the one portion of the suit land. Later on, defendant number 1 became dishonest and greedy, and he started to make attempts to grab the suit land belonging to the defendant number 2 and 3. As such, having no alternative, defendant had filed a proceeding under section 145 CRPC through their attorney. Later, they had also got implicated in the said proceeding. During pendency of the proceeding, both parties contacted the plaintiff and offered the plaintiff to purchase the suit land. At that time, it was clearly admitted by the defendant number 1 that he was in occupation of the suit land as a caretaker and owner of the defendant number 2 and 3, and assured the plaintiff that immediately on execution of sale deed, he himself vacated the suit land. That is their case.
So what is your defense?
My defense is I have purchased 1 kotha land from Prabodh Haloi. Prabodh Haloi and mother of the defendant number 1 and 2 has purchased land from Gauripada Ghosh by 2 different sale deed. Gauripada Ghosh executed 2 sale deed. One is for Prabodh Haloi, one is for Gauridas. Gauridas is the mother of defendant number 2 and 3. And the Prabodh Haloi sold land, 1 kotha of land to me, my vendor. So she will kindly see page 20.
Yes.
This is Lordship purchaser Pandalal Chaudhary, defendant number 1. Pandalal Chaudhary, Sampalal Chaudhary, and seller is Prabodh Haloi. Lordship got it? Now I have purchased the land at 30,000 in the year 1994. Original sale deed at page Lordship will find at page 1, page 21 is the 1 kotha of land. Lordship got it? 1 kotha of land under Doug number 34, KP Pata number 4, as per measurement 260 center, which is bounded by specific boundary. And Gauridas, the vendor of the mother of the defendant number 2 and 3 is Gauridas. Gauridas, South Pipeline, Nurul Haq, and 12 feet road on the Sandan Dekha. 1 kotha 10 acres of land has been purchased by Prabodh Haloi from Gauripada Ghosh. Gauripada Ghosh sold 1 kotha of land because 10 acres of land has been gone for construction of road. That is why I have been given 1 kotha of land. Now, Lordship will find original sale deed at page 22. This is a translated copy. This is Pandalal Chaudhary and Prabodh Haloi is the seller. Lordship, thereafter, my name has been included in the revenue record. I have ignored Patta also, page 34. Page 32 is the Jama Mandi, where my name is reflected after purchase of the land. Page 34 is the relevant portion, serial number 8, Pandalal Chaudhary. Type copy of page 34 also, after Jama Mandi.
Yes.
Pandalal Chaudhary, serial number 8, Lordship. And thereafter, Patta has been issued in my favor, page 36. Page 36 is a Patta.
You got it, serial number 8.
Serial number 8. Pandalal Chaudhary. Now, I have to take your Lordship to the WS what stand I have taken.
WS it is that page number?
WS has not been annexed with the appeal memo. That is why I have to take your lordship to the. Oh, wait. Before that, lordship can see the evidence.
No, first I'll let us see your defense.
Lordship. Lordship will find amended petition statement filed on 22/6/2011. On 22/6/2011.
Yes.
Now, lordship, from paragraph number 4.
Mm.
That if suit is bad for non-gender or necessary parties, answering defendants state that one Sri Triken Gogoi, Kunjolata Das, Prabodh Haloi, handler of the defendant number 1, common purchase, who purchased the land along with the great Gauri Das, original owner of the land, claimed to have purchased by the plaintiff from same owner, namely Gaurangapada Ghosh. At the same time, as such, all these associate persons are necessary parties to the present suit. In this suit, lordship have already seen the plain. All the partners has not been made parties. That is why that stand has been taken. Now, lordship, there are 7. The statements made in paragraph number 1 that the plaintiff are not able to prove and the answering defendant denies the same. It is denied that the plaintiff is the resident of the village Nadboma, Moja, Beltola, Gauhati. It is also denied the plaintiff is the owner of a plot of land measuring 3 quarters covered by Dag number Iman, which has been described in Schedule A appended with the plain. Answering defendant state that the plaintiff is not residing in the associate locality as such he is not known to the answering defendant. Statements made in paragraph number 2 of the plain are also false, baseless, and motivated. As such, answering defendant denies the same. It is denied that answering defendant was engaged by the mother of the defendant number 2 and 3 in construction of a house over the suit land, also entrusted to look after the suit land as caretaker. It is further denied that defendant number 1 was looking after the suit land as a caretaker by residing over one portion of the suit land. Later on, started to make attempt to grab the suit land belongs to the defendant number 2 and 3. It is denied that the defendant has filed proceeding under section 145 CRPC through their attorney. Later on, they got implicated in the suit proceeding. Answering defendant state that, in fact, statements made in plain and said paragraph regarding initiation of 145 proceedings by the defendant does not carry any meaning. Answering defendant further state that within the boundaries given in the schedule of plaint, there is no such land that is alleged in the suit land as stated by the plaintiff, and plaintiff is put to strict proof thereof. Why it has been stated, lordship? The boundary given in the sale deed is not in respect of 3 quarters of land. That is why it is very important. Boundaries given in the sale deed by which plaintiff has purchased the land from defendant number 2 and 3 is not in respect of 3 quarters of land. It is in respect of 1 bigha of land, total land. That is reflected and that has came to light during cross-examination. And from the exhibit 10, statements made in paragraph number 3, the plaint are false, concocted, and baseless. As such, answering defendant denies the same. It is denied that during pendency of the proceeding, both parties contacted the plaintiff and made also offer to attempt purchase the suit land. It also denied that relevant time defendant number 1 clearly admitted that he was in occupation of suit land as a caretaker of defendant number 2 and 3 and assured plaintiff immediately on execution of the sale deed he shall vacate the suit land. In this regard, answering defendant states that answering defendant at no point of time was caretaker of any portion of the land belonging to defendant number 2 and 3. As such, the question of giving assurance by him to the plaintiff who is not known to the answering defendant does not arise. Statements made in paragraph number 4 of the plaint are all out false, concocted, motivated. As such, answering defendant denies the same. It is denied that there was any situation that the defendant number 1 shall have any claim over the suit land and shall file an appropriate petition before the executive magistrate in a proceeding under section 145 CRPC. Raised statement in said paragraph regarding clarification made in defendant number 2 and 3 unto the plaintiff that the defendant number 2 and 3 and their petition never executed any sale agreement in favor of the defendant number 1. They have not applied for sale permission before the competent authority and not admitted by the plaintiff is put to strict proof thereof. Para 11. statements made in paragraph number 5, it is plain that upon assurance being made by the defendant, plaintiff purchases suit land from defendant number 2 and 3 out and false and baseless, hence answering defendant denies the same. It is also denied that after execution of the sale deed, defendant wants 38 to demand huge amount of money from the plaintiff taking advantage of the situation, and defendant number 1 is in occupation of suit land. In fact, answering defendant has no knowledge about the alleged purchase of the land by the answering defendant. These are the Lordship, the story has been denied. Now, Lordship, para 13 is important. Para 13, Lordship. Statements made in paragraph number 7 of the plaint are also false and baseless. As such, answering defendant denies the same. It is denied by an act of answering defendant right and title of plaintiff over the alleged suit land is all affected, and defendant number 1 is illegally occupying this so-called suit land. Answering defendant state that plaintiff on the strength of the so-called sale deed shown to have been executed by defendant number 2 and 3 in respect of the alleged suit land can acquire title, right title and interest over the same, and sale deed executed by Prabodh Haloy in favor of the answering defendant is not liable to be declared as illegal and void. That in regard to the statements made, paragraph number 8 and 9 plain answering defendant state that no cause of action on the specific date as alleged by the plaintiff thereafter. Thereafter the defense of the defendant. Paragraph 15. That one Prabodh Haloy, vendor of the answering defendant, that defendant number 1, was the absolute owner of a holder of plot of land measuring 1 kotha 10 letters covered by duct number 35 of patta number 4 of village Nadmuma Moja Beltola. Said land was purchased by Prabodh Haloy by sale deed number 6431 of 63, dated 1983 from what Gauranga Pada Ghosh, with boundaries as specified in schedule of the sale deed. It may be mentioned here that Gauri Das, the deceased mother of defendant number 2 and 3, had also purchased the land measuring 3 kotha, aforesaid dag and patta from Gauranga Pada Ghosh, same vendor. Height registered sale deed 6459 dated 1983. Same date, both the person, my vendor and Gauri Pada Das, both are relative lordship, purchased land on 1983. Besides this, Prabodh Haloy and Gauri Das and one Sri Kunjolata Das, Sri Tiken Das has also purchased land different by registered sale deed from Gauranga Pada Ghosh on the same day. Aforementioned 4 persons purchased in total 9 kathas, that is 1 bigha 4 kathas of land from Gauranga Pada Ghosh. All same sale deed has been executed on the same day. Total land 1 bigha 4 kathas of land. Original owner. Answering defendant state that at the relevant time, entire land was low-lying land, cultivable land. Said Gauri Das and Tiken Gogoi being resided at Shillong, both of them were not in occupation and possession of their respective plot of land. See, Prabodh Haloy, the vendor of the answering defendant, was in possession of his said plot of land measuring 1 kotha 10 letters of the aforesaid dag and patta, out of which 1 kotha land has been sold to the answering defendant by Prabodh Haloy by registered sale deed 2480 dated 3595, which has been marked as Exhibit A. Within boundaries specified in schedule of the said sale deed, said 1 kotha of land purchased by the answering defendant is bounded north Gauri Das, the mother of defendant number 2 and 3. South pipeline, east Nurul Haq, west 12 feet proposed road, and see Soron Deka. Soron Deka, Lordship is the employer secretary, now advocate, Soron Deka.
Yes, yes.
Lordship. It is pertinent to mention here that prior to execution of the registration of the sale deed 3595 said Prabodh Haloy entered into agreement for sale of the with the answering defendant on 6/8/1986 in respect of 1 kotha of land. Answering defendant state that on receipt of the total sale consideration price amounting to rupees 15,000, said Prabodh Haloy by executing said agreement for sale had delivered possession of said 1 kotha of land to the answering defendant. Accordingly, answering defendant occupied and possessed the said land by constructing Sali house thereon. Answering defendant state that remaining 10 letters of land was left by Prabodh Haloy for proposed road on the western boundary of the said 1 kotha of land. Lordship, all the person has purchased, so 10 letters of land has been left by all the parties for construction of road. Answering defendant state that as answering defendant was already in occupation of possession of 1 kotha of land as stated above, no formal delivery of possession of said land was required to be delivered by the vendor of Prabodh Haloy to the answering defendant. Thereafter, answering defendant had constructed his brick boundaries wall in the eastern and western side of the said land and got his name mutated in respect of the said land and has been paying land revenue regularly till date. I'm also paying regularly revenue. At the last town resettlement operation, the original dark patta in respect of the answering defendant has been changed and same has been renumbered as dark number 176 and KP patta number 7. Answering defendant has been occupying and possessing 1 kotha of land within boundaries as mentioned above by constructing his house and structure thereon. My defense is that. Hereafter, answering defendant states that Gauri Das, this is mother of the defendant number 2 and 3, during their lifetime, particularly in the last part of 89, has approached the answering defendant to purchase land measuring 10 lesas out of her total land, which is situated on the northern side of the land of the answering defendant. On being agreed, answering defendant said Gauri Das, since this is executed an agreement for sale in favor of answering defendant for transfer of the said 10 lesas of land covered by DAG number 35, KP patta number 4. Total consideration of rupees 7,500. On the day of agreement, said Gauri Das received and acknowledged the amount of rupees 3,000 from the answering defendant. As per stipulation made in the agreement, balance amount was to be paid at the time of registration of sale deed. But said Gauri Das, since this is instead of obtaining sale permission and registering the sale deed, demanded the balance amount on the assurance that she would execute the sale deed as early as possible. Upon such demand being made, answering defendant paid total balance consideration of rupees 4,500 to the said Gauri Das on 7/3/1990, which was received and acknowledged by her by said agreement itself. That has been exhibited also. It is to be mentioned herein that after receiving the total consideration of 7,500, Gauri Das delivered possession of the said land to the answering defendant. That is the northern side of the land. Petitioner has purchased from Prabhu. Answering defendant state that, as they said, Gauri Das and Tiken Das were not being resident of the land, their respective plot of land were gradually encroached by neighboring people. As a result, Gauri Das approached the answering defendant to purchase another 6 lesses of land along with earlier 10 lesses of land, and on being agreed by the answering defendant, possession of said 6 lesser land also delivered to the answering defendant by Gauri Das in the month of January 1995. Answering defendant stated that as per stipulation made in the agreement, said Gauri Das applied for sale permission before the Deputy Commissioner Kamrup as well as Gauhati Metropolitan Development Authority for sale permission in respect of 16 lesses of land. And said 16 lesses of land is bounded by presently Akash Ali and his brother, south land of answering defendant, west Alfaz Ali, east Nurul Haq. Answering defendant state that the said Gauri Das, after obtaining sale permission from the Deputy Commissioner Kamrup as well as GMD, had given the copy of the same to the answering defendant and assured that she would execute and register the sale deed after she being returned from Shillong. But since the said Gauri Das did not return up to the Gauhati and registered the sale deed as assured, later on answering defendant has came to know about death of Gauri Das. Sale permission has been obtained. Thereafter, Gauri Das, the mother of defendant number 2 and 3, died. Gauri Das, as stated above, answering defendant has been occupying and possessing this same by constructing house and structure thereon. That is 16 lesses of land. Said land being adjoining to his earlier 1 kotha of land, the answering defendant erected boundary walls surrounding the said land, northern, eastern, western side, adjoining the earlier boundaries walls, 1 kotha of land. It is pertinent to mention here that after date of Gauri Das, her son Gautam Das, in presence of defendant number 2, time to time has received various amount from the answering defendant and his man in respect of 6 lesses of land agreed to be sold by the deceased mother with an assurance to execute and register sale deed. But till date, neither Gautam Kumar Das nor his heirs of late Gauri Das has executed a sale deed. So I am possessing 16 lesses of land on the basis of agreement for sale of vendor of Gauri Das. Answering defendant stated that said Gauri Das, since deceased by executing the agreement for sale, agreed to transfer the aforesaid 16 lesses of land in favor of the answering defendant by receiving the consideration and by delivering possession of same thereafter. Present defendant number 2 had also received the various amount from the answering defendant time to time in respect of the said land as stated above. Answering defendant have been coming in occupation and possession of 16 lesses of land in pursuant to the said agreement for sale and has been continuing possession till date by constructing house and structure thereon, and answering defendant has already paid total consideration in respect of 10 lesses of land and ready to pay balance amount if any, in respect of 6 places of land. To the defendant number 2 and 3, and present plaintiff who is the claiming right in respect of property through defendant number 2 and 3 has been debarred from claiming any right of over the same and right of possession of answering defendant as protected under section 53A of the Transfer of Property Act. It may be mentioned herein that house constructed by the answering defendant over the 16 leases of land has let out by the answering defendant to various tenants. So my defense is, Lordship, I have purchased 1 kotha of land from Prabodh Haloi by specific boundary.
Okay.
On the northern side, there is land of Gauridas.
I will take 5 minutes break. A of the Transfer of Property Act.
Regarding 1 kotha 16 leases of land,
Yes.
Lordship, I kindly see Transfer of Property Act section 53A. May I read, Lordship?
Yes.
Where any person contracts to transfer for consideration of any immovable property by writing signed by him or on his behalf, from which the terms necessary to constitute the transfer can be ascertained with reasonable certainty, and the transferee has in part performance of the contract taken possession of the property or any part thereof, or the transferee being already in possession continues to be in possession in part performance of the contract, has done something in furtherance of the contract, and transferee has performed or willing to perform his part of the contract, notwithstanding where there is any instrument of transfer, that the transfer has not been completed in any manner prescribed therefrom by law, for the time being in force, transferor or any person claiming under him shall be debarred from entering against the transferee, and the person claiming under him any right in respect of the property which the transferee has taken and continued to be in possession, other than the right expressly provided by the terms of the contract, provided that nothing in this section shall affect right of the transferee for consideration who has no notice of the contract or part performance thereof. So I'm protected under section 53A. Because as per contract, I have been delivered possession, I'm in possession of the land. And it is also admitted position that I'm in possession of the land. There is no dispute to that effect. And Lordship, to ascertain the actual fact that from which defendant number 2 and 3 has, defendant number 2, 3's mother has Gauridas has purchased the land from Gauripada Das. Lordship will find Exhibit 7. That is very important. They have annexed, they have marked it as Exhibit 7. Lordship will get in C file, Lordship, I think. C file.
C1. No, C2, C1. Exhibit
7. Which has been marked by the plaintiff.
Yes, this is the agreement.
That is the no. That is the sale deed of Gaurangabada Ghosh, which has been purchased by Gaurangabada Ghosh from Chandratta Goswami. And Gaurangabada Ghosh has sold the land to the mother of the defendant number 2 and 3. Lordship, Gaurangabada Ghosh, Lordship got it. The land purchased by him is next page, Lordship.
Yes.
Sari Kotha Dohlesa. Lordship got it. Sarikotha Dolesa. Total land he purchased from Chandroto Goswami Sarikotha Dostesa. And same Bodupota Ghosh has sold the land to Goridas. Now pay exhibit 8 Lordship. Now exhibit 8.
Yes.
Goridas, the mother of defendant number 2 and 3.
And
seller is Godangapata Ghosh. Exhibit 7 is a purchase of Godangapata Ghosh. And exhibit 8 is the purchaser Goridas, mother of defendant number 2 and 3. What he purchased, Lordship will find at next last portion topsil. 3 quarters of land. Lordship got it, 3 quarters of land. And my vendor, Prabodh Haloi, now Lordship, I will take you to exhibit A, which has been edited by us. Prabodh Haloi, exhibit A, Lordship. Prabodh Haloi, by exhibit A, passes from Gauripada Ghosh, same vendor where Gauridas has purchased. Lordship got it? Exhibit A. Now Lordship will find this, the land in question. Ek kotha dohlesa, topsil. Lordship got it? Ek kotha dohlesa. That means 3 kotha has been sold to Gauridas and 1 kotha 10 lesas has been sold to Prabodh Haloi by Gaurangapata Ghosh. And Prabodh Haloi is my vendor. In respect of 1 kotha of land. 10 lesa has been given for construction of road. Lordship, may I clear, Lordship? Now, Lordship, again I will take your Lordship to the plane. Page 10. Prayer portion, page 16. My sale deed is not under challenge. Indeed, no prayer has been made challenging my sale deed.
Pardon?
Page 16. The relief. Plaintiff has prayed for a decree declaring title and resort plaintiff over the suit land, recovery of khas position of the scheduled plot of land, evicting the defendant number 1, myself, and all his men, employees, agents by removing his structure and permanent injunction. My sale deed executed by Prabodh Haloi was not challenged. No prayer has been made to set aside my sale deed by Prabodh Haloi. Only averment has been made, what you will find at page para 14. Page 14, Lordship. Defendant number 1, Lordship, middle portion. Defendant number 1 claim himself to be owner of a plot of land measuring on the basis of a sale deed executed by 1 Prabodh Haloi. Being deed number Iman, dated Iman, being Iman, it will worthwhile to mention that the Prabodh Haloi never had any title over the suit land. As such, he cannot sell any part of the same. Said sale deed executed by Prabodh Haloi is illegal, void, inoperative with regard to the suit land by the defendant number 1 cannot claim any right title over the suit land in view of the said sale deed. Only averment has been made. But no prayer has been made to challenge the sale deed that Prabodh Haloi has no right, title, interest to execute the sale deed in my favor. In respect of that land, my land has been revenue record has been mutated, corrected, patta has been issued in my favor. And Lordship will find who are the parties to the suit. Page 10 again, Lordship. Gautam Das and Kakoli Das, and I am the defendant number 1. Prabodh Haloi has not made party, nor Gaurangapata Ghosh or his legal heirs. if he died.
Whether any issue was framed on that count by the
I'll take your lordship then.
trial court?
No, only trial court has said that my sale deed has no.
No,
Court.
in respect of non-gender of necessary parties.
Lordship will find.
Yes, yes. Yes, put to.
Lordship, page 39. Issue. Declaration of right title over the suit land. This is a prayer. Now, Lordship will the
41.
page 41 is the issues. Whether suit is maintainable, if there is any cause of action for the suit, whether suit is bad for non-gender necessity parties, whether plaintiff has right title interest over the suit land, whether plaintiff entitled to a recovery of khas position of the suit land by which defendant number 1, what relief plaintiff is entitled.
No, in this case, there is no question of claiming any relief against the other persons. So they cannot be necessary party.
They cannot be necessary party, but without challenging my sale deed. My sale deed by which I have purchased, that is my defense in the suit, that I have purchased the land from Prabodh Halwe, and Prabodh Halwe purchased the land from Gauripada Ghosh, and defendant number, mother of the defendant number 2 and 3 also purchased the land from Gauripada Ghosh. 4 kotha 10 lessons of land. Out of them, 3 kothas has been sold to Gauridas, and 1 kotha 10 lessons has been sold to Prabodh Halwe. And from Prabodh Halwe, I have purchased 1 kotha of land. And boundary given in the sale deed is respect of total 1 bigha, 1 kotha of land. If let's say the 1 bigha, 1 kotha of land is the boundary of the sale deed, that has been reflected in the cross-examination. I will show the cross-examination part. They have said the total land 1 bigha, 1 kotha has been sold as a land. Though they have purchased 3 kothas of land, which includes my land. Whether they, by this agreement for the sale deed, they will execute the land on 1 kotha, 1 bigha, 4 kothas of land. That has been reflected during cross-examination. I will place the cross-examination part. Lords will find evidence of Julekha Khatun. I will show the cross-examination part. Lordship will find the cross-examination part of Julekha Khatun.
Right, page number 42?
No, no, it is not annexed. It is in the LCR. Lordship will find.
No, it is reflected in the judgment.
It is not reflected in the judgment. That is why that evidence has not been reflected in the judgment.
Okay. Julekha Khatun was examined as PW or
PW1.
PW1.
Lordship. Cross-examination part is very important. Lordship.
PW1 is not.
Before, after exhibit, also Lordship will find the cross-examination.
No, it starts from PW2 here. Copy. PW2 was a 1 to 2. It was again a Evidence and process. Itu two. Next to ours. It makes us three. Four. DW1. Cross of DW1. DW2. Do you have the certified copy with you?
Lordship. That's why only I have only one copy.
Here, the original is not available.
I think it will be available, Lordship. May I see it, Lordship?
Yes, you can check. It was easy. No.
Conference with this energy. After the course. It's 37.
But I have not find the sieve. But I have not find the sieve.
Therefore,
Only cross examination is then available.
Okay, let us go through it.
Lordship, I do not know total land covered by Doug number 35 of Patta number 4. There is no mention of Doug number 35 and Patta number 4, number exhibit 10. Total land shown in exhibit 10 is 2 kotha 6 lesses of land. That means, Lordship, the vendor of the plaintiff, that is defendant number 2, 3 has in their name 2 kotha 10 less 6 lesses of land. As per exhibit 10. Plaintiff has filed photocopy of the trace map along with the plane, but the same is not exhibited by the plaintiff in this resident. The defendant has cross-examined the PW1 on this document. As such, says photocopy of the trace map is marked as exhibit A. Total land of Doug number 35 as shown as exhibit A is 1 bigha 3 kothas of Doug number 26 situated in the northern side of the Doug number 35 as per exhibit A. There is a pipeline in the southern side of Doug number 35A as per exhibit A. Doug number 35 is situated in the eastern side of 35 as per exhibit A. The Doug number 38, 45, 44 and 43 are situated on the western side of Doug number 35. As per exhibit A, aforesaid boundary is also shown to be boundary of 3 kothas of land purchased by me. Total land has been shown, 1 bigha 1 kotha has been shown in the boundary, that is exhibit 14. So, Lordship, the land purchased by him, though as per say the 3 kothas of land, the boundary has been shown total land 1 bigha 4 kothas of land. That is admitted. I know that Gauripada Ghosh was the original owner of the land, but I do not know who was the owner prior to the Gauripada Ghosh. As per exhibit 7, Gaurangapada Ghosh has another land on the eastern side of the land purchased by him. I do not know to whom Gaurangapada Ghosh had sold. That means Gaurangapada has sold to Prabodhalwe. I do not know to whom Gaurangapada Ghosh had sold the land, the other than Gauripada Ghosh. Gauridas. Nor I do not know how much land was sold. I do not remember when Gauridas dies. I had never seen Gauridas. I know that Gauridas used to stay in the North Gauhati. My vendor are still alive, but Kakolidas stayed at Dispur, Gauridas stayed at Shillong. They were not cited as a witness in this case. They have not called their vendor as a witness. They are not cited as a witness in this case. I know Pannalal Chaudhary since the time of negotiation for purchasing land was initiated. The fact that Pannalal Chaudhary was engaged to look after the suit land was sold to me by the vendor and also by Pannalal Chaudhary. They did not state to me as to since when, date of year, they have engaged Pannalal Chaudhary as to look after this land. I do not know when 145 proceeding was initiated between vendors and Pannalal Chaudhary, but I know that one such proceeding was initiated. Said 145 proceeding was compromised, but I do not know the date and year of compromise. No document or order of such compromise is filed in this case. I do not know that the said 145 proceeding was dropped for non-prosecution by the vendor. 145 proceeding was closed. My name is not mutated in Exhibit 1. Exhibit 1 is the respect of Patta number 32, Doug number 165. That the date and month and the year the Pannalal Chaudhary told me that they would vacate the land after purchase. Same is not remember me. At the time I had my husband. At that time I and my husband and the defendant number 1, 2, 3 were present. Pannalal Chaudhary was occupying 3 kothas of land belonging to the Gauridas. I do not know the name of person in the boundary of the suit land. I do not know if Gauripada Ghosh sold his land measuring 1 kotha 10 lesas to Prabodhalwe in the year 1983. Defendant number 1 has 1 Tinasali house and Gumti, small site over the said plot of land. Pramod Das is the relative of my vendor and reside at North Gauhati. Akkash Ali is the friend of my husband. He reside at the house pet. It is not a fact that defendant number 1 did not tell us he would vacate the land. It is not a fact that defendant number 1 had not demanded money. my vendor could not deliver possession of the land purchased by me. Possession has not been handed over. My vendor told me that Gauridas had not agreed to sell the land to defendant number 1. Statements made by me in paragraph number 8 of the examination in C from the 4th line onwards are told me by my vendors. The Gauridas or my vendor never instituted any case for cancellation of the alleged force agreement or sale in favor of defendant number 1. Gauridas did not file any objection in respect of the sale permission in the name of defendant number 1. I do not know if the name of defendant number 1 is mutated over 1 kata of land, nor I do not know if he is paying land revenue. I do not know if Gauridas gave 16 lasses of land to the defendant number 1 and delivered possession with promise to sell the same to him. It is note to fact that suit land and the land in possession of defendant number 1 are not the same. So, Lordship, trial court has, how decree has been passed. Lordship will find in judgment that trial court has held that I have no right title over 1 kata of land also. Lordship will find trial court judgment at page 38.
Relevant paragraph?
Para 22.
Yes.
Considering every matters on record, it is to be determined if the plaintiff has been able to prove each case independently or not. Notwithstanding everything on record, it seems that plaintiff have stated that she, on the assurance of defendant number, purchased the suit land from defendant number 2 and 3 in presence of Akash Ali, Pramod Das, and her husband. After execution of sale, the defendant was started demanding huge amount of money. Defendant number 1 claimed himself as owner of the suit land on the basis of a sale deed executed by Prabodh Haloi. Height sale deed number Iman. Prabodh Haloi never had any title over the suit land. As such, he cannot sell any part of the land. Trial court has given a finding that Prabodh Haloi did not have any right to sell the land in favor of me. Without challenging the sale deed, without making Prabodh Haloi a party, my sale deed by which I have purchased the land was not under challenge. But trial court has given a finding that Prabodh Haloi did not have any land and no title over the land. And I have exhibited the sale deed executed in favor of Prabodh Haloi by Gauridas, Gauranga Ghosh. Defendant number 1, on the other hand, pleaded that Prabodh Haloi was the absolute owner of title holder of a plot of land, 1 kata 10 lasses of land covered by Dag number. Said land was purchased by Prabodh Haloi by sale deed number Iman from 1 Gauranga Ghosh. Late Gauridas, deceased of the mother, defendant number 2 and 3 also purchased 3 katas of land, aforesaid Dag and Patta from Gauranga Ghosh by deed number 1. Besides, then Kunjalata Das deserted. Lordship, already I have shown this sale deed by which I have purchased that has been marked an exhibit. The sale deed executed in favor of Prabodh Haloi and the sale deed executed in favor of Gauranga Ghosh by his vendor regarding 4 kata 10 lasses of land. Out of that, 3 kathas has been sold to Gauridas and 1 kata 10 lasses has been sold to Prabodh Haloi. Now, finally, Lordship, issue number 3 regarding Lordship the whether suit is bad for non-judgment necessary parties, finding it at issue number 3, page 46. Page 46, page 30. Defendant number 3, the 1, Tiken Gogoi, Kunjalata Das, Prabodh Haloi are vendor of defendant number 1. Gauridas, original owner of the land, namely Gauranga Ghosh, are necessary parties in the present suit. However, the matter of right title and interest as discussed aforesaid has been determined in respect of the sale deed number exhibit 14. Under such circumstances, the issue at which parties are at variance can be decided in absence of the aforesaid person. Accordingly, such persons are not necessary parties in the suit land. When my sale deed was held to be invalid, my vendor has been declared to be no right title and interest in respect of the land. When I have exhibited the sale deed executed in favor of Prabodh Haloi and sale deed in my favor executed by Prabodh Haloi, there is no finding to that effect. Only said that Prabodh Haloi did not have any right title interest. Ultimately, suit has been decreed. Appellate court also same thing, Lordship will find at page 69. Short judgment.
Relevant paragraph.
Possible page 73. Decision and reason thereof. While discussing the issue pertaining to right title interest and entitlement of khas position, Mujib number 1 gave primary authority of probabilities regarding registration of assignment while pursuing the case record 1 particularly. Probabilities rendered by the appellant as defendant number 1 in the aforesaid title suit is clear that apart from copy of the agreement for sale, which has been marked as Exhibit E, the appellant had nothing to show regarding genuine position he had over the suit land. I have exhibited Exhibit E, this agreement for sale with Goridas. Exhibit E again is an unregistered deed of agreement for sale, and evidence and value of the said agreement is always negligible to appreciate the title of the suit land. Very position alleged to be given to the appellant was in the capacity of a caretaker. As such, position also does not get weightage for deciding the title of a property. Defendant also could not prove derivation, the title from the actual vendor, whereas the respondent number of the case had all the recognized probabilities in her favor. There is a vast difference between the registered sale deed and the unregistered sale for agreement. Court only recognized a registered instrument which is registered as per Agreement of Registration Act, though appellant Exhibit C by claiming that he had purchased the land from Prabodh Halloi, but the appellant failed to prove execution of sale deed by calling the witness of that deed. I have examined the witness of the who has signed as a witness in the sale deed, and sale deed has been exhibited. Since the claim of the appellant was on the basis of Exhibit C, burden is upon to him to have proved the sale deed first, but merely exhibiting the sale deed not sufficient to come to the terms of the appellant had bona fide title. Discussion above, both facts and law, there is no error made in trial court below passing the decree. The point is decided negative against the appellant. So my sale deed has been exhibited, Exhibit C. Witness who has signed the sale deed has been examined. He is not. Horrendous is the witness number 2, who is the witness of the sale deed by which I have purchased the land from Prabodh Halloi.
Why his evidence was ignored by the trial court?
I do not know, Lordship. This evidence was ignored, but in fact, they have not examined their vendor. Plaintiff of the suit by which they have purchased 3 quarters of land, giving boundary of 1 bigha 4 quarters of land. They have not examined the vendor of their plaintiff. Lordship will find the evidence of Horrendous, who is the witness to the sale deed.
He was examined as
PW2.
PW2 or DW2?
DW2.
Yes.
Horrendous, son of Ram Gujarat. Para 3, Lordship. Prabodh Halloi has purchased 1 kotha 10 acres of land by Dag number Iman from Sri Gauranga Ghosh by registered sale deed number Iman 83 Exhibit A. On the same day above, Srimoti Gauridas has also purchased 3 quarters of land professed Dag and Patta from Gauranga Ghosh by another registered sale deed. Lordship, I have already shown 2 sale deed by which Gauranga Ghosh sold land to Gauridas and my vendor. 3 quarters of land aforesaid Dag and Patta from Gauranga Ghosh by another registered sale deed. Besides this, Prabodh Halloi and Gauridas and Kunjolata Das and Tikendas also purchased their respective plot of land from Gauranga Ghosh on the same day. It may be mentioned herein that said Kunjolata Das was my wife. Lordship will find para 5. Indian 86 said Prabodh Halloi agreed to sell 1 kotha of land, 1 kotha of 10 lakhs of defendant number 1, Pandalal Chaudhary, to that effect. One agreement was executed, Exhibit B. In the said Exhibit B, Exhibit B2 is the signature of Prabodh Haloi. Exhibit B3 is my signature as witness. On the day of execution, Prabodh Haloi handed over position of one kotha of land to defendant number 1. Panalal Chaudhary since then defendant number 1 in occupation of the position of the land. Thereafter, Prabodh Haloi has exhibited Exhibit C, executed registered sale deed in respect of one kotha of land in favor of defendant number 1, which is bounded by Iman. Exhibit C1, C10 are the signature of Prabodh Haloi, who were put before me. I was present at the time of execution of registration sale deed, though I did not sign as a witness. Exhibit C11, C2 are signature of Arab Ali and San Muhammad Ali, which were witness to the sale deed. Both of them are known to me, and presently both are not alive. Both the witnesses has expired. And Lordship Kunjal, Prabodh Haloi is the brother-in-law of the present Foreign Das. Late Gauridas and Tikendas were residing in Shillong. At the time of Gauridas situated at adjacent boundary of the defendant number 1, there is none to look after the sale of Gauridas taking advantage of this. These are the things also. So I have, as far as possible, I have proved the vendor sale deed also. Prabodh Halai's signature. Because Prabodh Halai is the brother of Foreign Das. But his evidence was not discussed by the trial court, nor by the appellate court. Only saying that registered sale deed is always considered as a valid document unless it is disputed. So sum and substance is Lordship.
This is your case.
This is my case. Secondly, I will place two judgments on these points. When boundary of a land has been given 1 bigha 4 quarters of land, whether he is entitled for decree for recovery of possession or title, this court has decided on this point. I will give the judgment. First is 2016 1 GLT 523. Relevant paragraph is para 20. In view of the matter, though I can read para 19 also, that is 11, but relevant position. In view of the matter, though plaintiff has purchased along with the Narshuddin 1 bigha 1 kotha 16 lesses of land, though admittedly plaintiff has taken 3 kotha 18 lesses of land, having regard to the wrong boundaries given in the Schedule B, in the facts of the case, no decree can be passed in favor of the plaintiff. Here, admittedly, he has admitted that total land shown in the exhibit sale deed is 1 bigha 4 kothas of land. And the case map, which has been exhibited, which has been enclosed with the along with the plane, also says 1 bigha 4 kothas of land. And total land has been shown as a scheduled land. Next judgment is Lordship 2015 3 GLT 523. Last paragraph. That is Lordship regarding registered document.
Registered?
I have exhibited the registered sale deed executed in my favor.
No. What is the finding here?
Finding will find last portion also. The contents of the defendant therefore is hid by section 92 of the Evidence Act, inasmuch as oral evidence of the defendant number 1 cannot override the registered written agreement executed by them. That is regarding registered document. Being the position, third point determination also given in favor of the plaintiff respondent. Once all the points determined are decided in favor of the plaintiff, respondent, the appeal must fail and accordingly dismissed. Secondly, Lordship, when relevant evidence That is Lordship the horrendous. I have proved my sale deed. I have exhibited the, I proved the signature of Prabodh Haloi by his own relative, brother-in-law. That Prabodh Haloi's signature has been proved by the brother-in-law, that is my brother's signature, brother-in-law's signature. And the witness also stated that has not been considered by the trial court, not discussed anything, only ignored the evidence without saying that Prabodh Haloi, the sale deed exhibited by me, cannot be relied on. 2019 6 SCC 409. Dr. will find page 40292.
Or
Court, page 420. The state judgment.
420.
2019 6 SCC. Para 9.2. Dr. got it? Now, I'm not reading the whole judgment, only relevant portion. Now, so for a submission on behalf of the plaintiff that as the research sale deed dated 22/6/64 was not challenged by the defendant by way of suit, even counterclaim. Therefore, it was not open for the defendant to challenge the same is concerned at the all the outset is required to be noted and subsequent observed here above. Krishna Appa was not a signatory of the said document or sale deed, and therefore it cannot be bind him or his heirs, even otherwise, as held by this court in Vidyathar, in a suit filed by the plaintiff for declaration on the basis of a registered sale deed. It is always open to the defendant, who is a stranger of the sale deed, to raise a plea that sale deed was void, fictitious, collusive, not intended to acted upon, nor binding upon him. In the aforesaid decision, it is observed that held that by this court, that is a person who, in his capacity as a defendant, can raise any legitimate plea available to him under the law to defeat the suit of the plaintiff. In para 21, this court observed as held as under. Now, therefore, therefore, in the facts and circumstances of the case, we are of the opinion that without even challenging the sale deed, exhibit P1, by way of the independent proceeding in a suit filed by the plaintiff seeking for a declaration that has become the owner of the portion to the registered sale deed, it is always open to the defendant who is a standard of sale deed to raise the plea that either the sale deed is not binding upon him, and same was not without consideration, it is a nominal sale deed, is void, fictitious, for that matter, collusive, not intended to be acted upon. So my corollary is, Lordship, my sale deed is not challenged by the plaintiff in the original claim. Without challenging the sale deed and right of the Prabodh Haloi to execute the sale deed, trial court has held it that my right has not been there because Prabodh Haloi did not have any title. In fact, I have exhibited my patta, which has been marked as Lordship fine, Patalal Suri's evidence. I have marked my patta . Research sale has been marked as Exhibit C, by which I have purchased the land from Prabodh Haloi. And name of the witness has been marked, also proved as Exhibit C11 and C2 are the signature of witness Arab Ali and son Muhammad. And the mutation order Exhibit D. Secondly, the agreement for sale by Gauri Das, the mother of the defendant number 2 and 3, which has been marked as Exhibit E. And signature of Gauri Das, Exhibit E3, E4. And Exhibit E5 is the acknowledgement received by Gauri Das. Sale permission has been exhibited as Exhibit F. Regarding Lordship, 4 lessons of land, there are 16 lessons total, 16 lessons of land. Exhibit F is a sale permission given by the competent authority. Exhibit G is a money receipt, and Exhibit H1 are the land revenue receipt, and certificate of the Jama Money in respect of plan, and Exhibit L is a copy of the patta in respect of the plot of land, patta number 31. So I have proved title by sale deed executed in my favor by Prabodh Halo, and there is no dispute that Gauranga Pada Ghosh is the owner of the land, original owner of the land. And Gauranga Pada Ghosh has sold 3 kathas of land to Gauri Das and 1 katha 10 lessons of land to Prabodh Halo. And from Prabodh Halo, I have purchased 1 katha of land. So without challenging my sale deed, how they can claim right over the land? And when this boundary of the sale deed describe 1 bigha 4 kathas of land, how they can execute it, they can get a relief in respect of 3 kathas of land. And in fact, Gauri Das and his son thereafter did not have 3 kathas of land as per Jama Mundi. They have only 1 katha 16 lessons of land. So sum and substance, my case is this. That is why the supplemental question of law has been framed regarding Exhibit C, that is my sale deed. And that is why supplemental of 2, whether plaintiff respondent is entitled to decree of receipt of 3 kathas of land as per Jama Mundi Exhibit 10. His vendor had no title position in respect of 3 kathas of land. As per Exhibit 10, only total land has been shown.
Okay. Yes, Ali.
Met with law. Not the past substantial question of law, my lord, which was framed, my lord, regarding Exhibit C. Not in my Amud submission, my lord, it is not applicable in this case. Exhibit C is the, my lord, sale deed of my learned friend, my lord, client. And here, my lord, it is admitted, my lord, that he purchased, my lord, 1 katha 10 lessa of land, my lord. His owner, my lord. 1 katha 10 lessa. Gauri Das, my lord, purchased 3 katha by my lord, sale deed number 6459. This is also relevant. Sale deed number 645983. 3 katha, my lord. And subsequently, my lord, Prabodh Haloi, my lord, purchased 1 katha 10 lessa by sale deed, my lord, 6461. Subsequent sale deed.
Same day.
Subsequent sale deed, my lord. Now, I have no claim over this land, my lord, of Prabodh Haloi. Whether he has purchased or whether he has sold. This land, my lord, 1 katha 10 lessa is not a disputed case in this suit, my lord. Disputed suit, my lord, 3 katha, which the plaintiff have purchased from the legal heirs of Gauri Das. And that was, my lord, illegally possessed by defendant, my lord. And regarding, my lord, therefore, my lord, the question of challenging the sale deed of Prabodh Haloi or, my lord, the defendant number 1, my lord, is not, my lord, necessary in this case because I have no grievance against that sale deed. So, my lord, in everywhere, my lord, suit land is 3 katha, my lord. I have purchased 3 katha from the original owner, and that was not the case. Therefore, my lord, suit was filed. And regarding this 1 katha, my lord, separate suit has been filed by defendant number 1, and suit is pending. And he claimed right title interest over this said 1 katha by virtue of the sale deed, my lord, title suit, my lord, 116/2019, that is still pending. Now, regarding, my lord, defining the boundaries, my lord, the trial court has discussed, my lord, page 45, paragraph 24. I have perused exhibit 14 at length, which is the by which the plaintiff claims to have purchased the suit land from the defendants. Plaintiff number 1 deposed in a cross-examination that the total length of the dark number 35, as shown in the exhibit A, the trace map, is 3 figure 3 kata. Dark number 26 is situated on the northern side of dark number 35 of exhibit A. There is a pipeline on the southern side of dark number 35. The dark number 34 is situated in the southern side, eastern side. The dark number so are situated on the eastern side of the eastern side as per exhibit B. South boundaries tallies with the boundaries mentioned in the schedule of the plant. Exhibit 14 is an original copy which goes to show that suit land has been purchased by the plaintiff from so and so and so and so, defendant number 2. Therefore, there is no difference or discrepancy in the boundaries. And regarding substantial question number 2, Jawabandi lordship knows Jawabandi or mutation does not create any right or title, my lord. It is for the purpose of paying the revenue taxes, my lord. So, my lord, Jawabandi is not a title, my lord. Title comes from my lord, sale deed. Sale deed, my lord, admittedly three katas, my lord. They have not disputed that position also. And it is not the case of the defendant that their portion has been, my lord, within these disputed 3 katas of land. They have never disputed that their land, the one that which has been parcelled by the defendant number 1, he never claimed that his land is within these three katas. So, and he's claiming over 16 lessons of land by law by unregistered sale agreement, and which is also discussed by law. In paragraph 26, my lord. Page 55. DW1 deposed that he has not given evidence of the witness of exhibit A. The 4 boundaries are not mentioned in exhibit E. Exhibit E is agreement, unregistered agreement. Exhibit E is an unregistered agreement. As per exhibit E, position of the land has not been mentioned. He and Gopidas have with the same tag and parcel. In exhibit 3, the schedule are not mentioned. He does not know if the citizen of the Gopidas sold the land to the plaintiff. Consequently, it seems that plaintiff has been able to prove the case as regards the sale of the land by exhibit 14. Exhibit 14 is the sale deed of plaintiff. The other documents also goes to substantiate the claim of the plaintiff as regards the suit land. So on the basis of unregistered agreement of sale, my lord, he cannot claim right title interest, my lord. And this issue has been also discussed in the by the learned appellate court, my lord. In paragraph page 73, my lord. Page 73, my lord. While discussing, lordship got it. While discussing the issue pertaining to right title and interest settlement of cost position, the learned Munship number 1 gave primacy to the authenticity of the probabilities regarding the registration of assignments. While pursuing the case record, while perusing the case record, more particularly the probabilities rendered by the appellant as defendant number 1 in the aforesaid title suit, it is clear that apart from a copy of agreement for sale, which is exhibited as exhibit E, the appellant had nothing to show regarding genuine possession he had over the suit land. Exhibit E is again an unregistered deed for agreement for sale, and eventually evidential value of the said exhibit is eligible in appreciate title on suit. The very position alleged to be given to the appellant was in the capacity of caretaker, and thus also does not get weightage for deciding the title of the party. So on the basis of undisputed agreement, my lord, he cannot claim title, my lord. And he did not file any, my lord, suit for specific performance of contract.
How can he file because the vendor has already died?
My lord, legal heirs are there, my lord. Land was built in the name of legal heirs. And I have passed it from the legal heirs, my lord, of the original owner. So the trial court as well as the learned appellate court has no error in this case, my lord. And the substantial.
No, you see, Mr. Ali, the cell deed has not been challenged.
No, my lord. Sell it of defendant number one, my lord. This is not a dispute. This is not within the disputed land, my lord. I have claimed, my lord, 3 kathas, my lord, from my original owner. Original owner, my lord, passes 3 kathas, my lord, from 3 kathas, my lord. And that is, my lord, prior to the sale deed of Pramod Hamri. So his land, my lord, is not within the disputed land. So question of challenging his deed, my lord. If I claim, my lord, more than 3 kathas, my lord, then the question would be there, my lord, then his deed is required to be challenged.
Then why you have write him as a defendant number 1?
My lord, he is my lord, illegally causing the land of the Gauhati, my lord. He is not vacating the land. I am not claiming his part, my lord, 1 katha, he parcel from Pramod Hamri. The plaintiff, my lord, nowhere says that, my lord, 1 katha parcel by the defendant number 1 is within the 3 kathas. So question of, my lord, challenging his deed, my lord, is not required in this case. Immediately, my lord, total land is 4 total land, my lord, 4 katha 10 lesser between these two sale deed. Sale deed of Pramod Hamri and Gauhati. Gauhati parcel 3 kathas, Pramod Hamri parcel 1 katha 10 lesser. From 1 katha 10 lesser, defendant number 1 parcel 1 katha. From 3 katha of Gauhati, I have parcel entire 3 kathas. So there is no dispute, my lord, that his portion is within this land, and I am claiming his land. If I would have claimed his land, my lord, then question, my lord, his sale deed ought to have been challenged.
Yes, Mr. Goswami, is it the position?
And he has filed suit, my lord, claiming his land, my lord.
Before that, Lordship, kindly see there.
So
Page 14, Lordship. Already, that is already Lordship knows, because on earlier occasion it was reset for hearing. I said that I have to make an inquiry regarding the suit filed by me regarding my declaration of title of 1 katha of land. That suit is pending.
So it is not in dispute that you have filed another title suit. Okay.
claiming a title is by virtue of the sale deed.
Executor Pramod Hamri.
So Schedule A is the land.
Lordship, what he has stated in his submission, Lordship, can record it. Page 14 of the appeal memo. Page 14 of the appeal memo. The title suit of 197 of 2020, which has been filed by him. Page 10 of the appeal memo. Now I will take page 14. Lordship, got it? Page 14. He is claiming in submission was made. That is why I make a submission that his submission should be recorded. Defendant number one, Lordship got it in middle question. Defendant number one claim himself as owner of the land, part of the suit land, on the basis of sale deed executed by Prabodh Halloway. Deed number Iman dated Iman, by serial number Iman. It is worthwhile to mention here that Prabodh Halloway never had any title over the suit land. As such, he cannot sell any part of the same. Said sale deed executed by Prabodh Halloway is illegal, void, inoperative. Now he make a submission that he is not claiming right on the basis of sale deed which I have been purchased. He make a clear submission in the suit that I cannot acquire a right because Prabodh Halloway did not have any right. And I have proved this sale deed executed in favor of Prabodh Halloway, and therefore Prabodh Halloway says the land to me. Now he make a submission before his honorable court that he is not claiming the right over the land which I have purchased from Prabodh Halloway. And Lordship has recorded that my submission. On last occasion, Lordship has recorded that I have to make an inquiry regarding suit pending, regarding my declaration of right title interest. In
Last
respect,
occasion means?
on earlier occasion, it was listed before the Lordship. And that day, on the hearing, I made an adjournment, praying that one suit is pending between the parties regarding declaration of right title interest.
Okay. So Doug number, patta number of both the lands are same.
Same.
Mr. Ali?
And boundary given in the sale deed in this suit is regarding 1 bighah 4 kathas and odd. In the sale deed, as well as in its suit, boundary is given is 1 bighah 1 katha 4 places of land. So he will get the, on the basis of sale deed, he will cover entire land. Is it possible? And I have made a specific stand that Gauri Das was resident of Shillong. He has left the land unoccupied. Thereafter, some nearby people has occupied his land. Some portion of the land was remained 6 lesas. So 6 lesas is made an agreement with me to sell the land. Accordingly, agreement was executed. Advance has been taken. Sale permission has been taken by the authority, from the authority, by Gauri Das itself. I am occupying only 6 lesas of land of Gauri Das on the basis of agreement for sale. And Lordship will find my sale deed. Lordship will kindly see boundary page 21. My boundary from which I have purchased. Not Gauri Das. Lordship got it? Not Gauri Das. South pipeline, East Muhammad Nurul Haq, and West 12 feet road. Gauri Das is on the northern side of me, from whom Gauri Das' son and daughter he has purchased. Now he has given the entire land as a boundary, and I have been made party. And trial court has said that I have no right title interest on the basis of sale deed executed by Prabodh Halloway. How it can be without challenging my sale deed?
Yes, Mr. Ali, are you confusing? Are you confusing the boundary of the of both the land?
No, the findings of the trial court, my lord, and sale deed, my lord, original sale deed produced, my lord, of my owner.
No, you see, page number 21 is a schedule of the land.
Page 20, my lord.
And
Sale deed of defendant number 1.
And the description of the boundary in the schedule A of the title suit number 116 of 2019 are almost same.
Yes, my lord, this is the same, my lord, because he is claiming land by virtue of this schedule, my lord.
Hmm.
He is claiming right title entitlement by virtue of this schedule, my lord.
Okay.
So this is not my schedule, my lord. This is the schedule of the land of the schedule one.
No, duck number, pattern number is same.
Same, my lord. Patta same. Patta the same, my lord.
Hmm.
Because land was not, my lord, partitioned, my lord.
Regarding Lordship, he made a submission that already another suit is pending. Lordship can see order dated 22/7/25 of this sonor report. 22/7/2025. This honorable court's order.
Yes.
So the if subsequent suit is decreed, he will get his share.
How?
But take the subsequent suit which is pending. And he's claiming the right title interest on the basis of self-deed, my lord. And he has not silenced my self-deed.
Hmm.
And his suit is subsequent, my lord, after the concurrent findings of the court.
Okay. Have you gone through the decision referred by him? These decisions.
Regarding on this, my lord.
Yes, regarding the challenge of the cell deed. You have not gone for the same. So Goswami, furnish a copy of the judgment to him or the citation.
I will give him.
So we'll keep the matter as part that we'll list in the first week of April. Only to answer the.
And regarding my lord, the annual over, my lord, on the basis of mutation, wrong, I will place this argument.
That is well settled.
Well settled, my lord. So
That is
this
well
is not
settled. No judgment is required on that
Lordship.
point. And Mr. Goswami also not denied the same.
Lordship.
Heard
So-
Mr. Goswami, learned counsel for the appellant, and Mr. R. Ali, learned counsel for the respondent. Recess and list the matter as part heard on
7th April.
7th of April.
Obliged, Lordship.
Item 27.
My lord, respondent has not appeared, my lord. Title appeal dismissed on the ground of condonation of rejection of condonation of delay of only 17 days, my lord. And accordingly, substantial questionnaire was framed, my lord.
Okay. For the delay for
Only 17 days, my lord.
rejection of the petition for condonation of delay.
Resulting, my lord, dismissal of appeal,
The first appellate court has dismissed it. Therefore, this
my lord. But today, my lord, the respondent is not present,
Absent.
my lord. Short date may be given.
short date. Okay.
my lord.
Heard Mr. Padgiri, learned counsel for the appellant. None appears for the respondent on call. List the matter after a week. Okay.
26.
My lord. Obliged.
Any other matter? Copy এটা review petition ছিল আর কি। ৰাতিপুৱা মেনশ্যন কৰিছিল ডি মজুমদাৰ এই মেটাৰটো এটা জাজমেণ্ট আছে তাতে যিটো ৰিভিউ কৰিব ফাইট কৰিছে এই জাজমেণ্টটো কপি এটা মোক দি দিবচোন
May I please, my lord?
Yes, you are for the appellant.
Yes, my lord. My lord, in this case, although service is complete, but no one has entered for the respondent, my lord. There is order dated, my lord, 31/2025, my lord.
Okay.
And my lord, substantial question of law, lordship will find my lord, order dated 12/6/2000.
So not today, Mr. Gupta.
My lord,
We'll fix another date.
my lord.
Heard Mr. Gupta, learned counsel for the appellant. List the matter on 31st March.
Obliged.